Okay, ladies and gentlemen, this is the Standing Committee on Citizenship and Immigration meeting number 33, Monday, April 30th, 2012. This meeting is also televised. It's pursuant to the order of reference of Monday, April 23rd, 2012, Bill C-31, an act to amend the Immigration and Refugee Protection Act and several other acts. We have two guests today for the first hour. Martin Collicott. We've been here before many times. Welcome back, sir. He's with the Center for Immigration Policy Reform. We have Mr. Peter Scholler, who's the Director of Refugee Forum, Human Rights Research and Education Center, University of Ottawa. How long do they have?
10 minutes.
10 minutes each, sir. Mr. Collicott, we'll start with you.
Thank you, Chairman. I will try to stick to my 10 minutes this time. Canada has a long and impressive record of providing protection to refugees. In per capita terms, we're among the world leaders with respect to how many we resettle from overseas, as well as the number and percentage of asylum seekers to whom we grant refugee status and the range of benefits we provide. While there's a strong public support for accepting reasonable numbers of genuine refugees, many Canadians also believe that there are serious problems with the current system, and Canadian generosity is being widely abused. I think it's important to recognize that when Canada signed on to the United Nations Refugee Convention, we had no expectation of becoming a country of first asylum for any significant number of refugee claimants. After World War II, we resettled more than 180,000 displaced persons from Europe, and subsequently thousands who fled Hungary in 1956, Czechoslovakia in 1968, as well as Asians from Uganda in the early 1970s and Indochina boat people later in the decade, which included, by the way, some of my wife's family. Canada did not expect to be a country of first asylum, largely because of our geographical location. To get here, the vast majority of refugee claimants have to travel through countries where, under generally accepted international rules, they could have sought asylum, indeed should have sought asylum if their real purpose was to reach a safe country. And I might mention in this regard that my concern over the shortcomings of our refugee system, my own concerns, started in 1986 with the arrival off the coast of Newfoundland of a boatload of 150 people who said they fled from Sri Lanka. It was later revealed, however, that they'd been living in Germany for several years, where some of them already had been granted refugee status and decided to move on to Canada in the expectation of receiving more generous benefits here. We had a chance to bring this sort of situation under control just a few years later when legislation to create the Immigration and Refugee Board was drafted. It was our intention to establish a list of what are known as safe third countries, that is, safe countries where asylum seekers should have made their refugee claims before moving on to Canada, looking for more generous benefits, which is a practice known as asylum shopping. The establishment of a safe third country list would have prevented us from being deluged with claimants who were not entitled to make claims in Canada because they had opportunities to make them in the safe countries they'd passed through in order to get here. Unfortunately, an influential and persistent refugee lobby was able to convince the then Minister of Immigration that no country in the world was safe except Canada. And as a result, our refugee determination system, which was designed to accommodate a fairly limited number of claims, has been largely overwhelmed ever since. This has not only slowed down the processing of claims by applicants who genuinely deserve our protection, but has cost an immense amount of money. John Mannion, a former Deputy Minister of Immigration and Secretary of the Treasury Board, estimated before a Senate committee in 2001 that the cost of the refugee system in Canada amounts to billions of dollars a year. The cost associated with claimants is estimated in the range of $50,000. In comparison, our annual contribution that's the cost associated with individual claimants is $50,000 a year. In comparison, our annual contribution to the United Nations High Commission for Refugees amounts to only about $2 to $3 a year for each of the refugees and internally displaced persons the UN cares for in its camps around the world. The reason why we spend so much more money on the processing of asylum seekers in Canada than on refugees in UN camps is that over the years a highly organized lobby of refugee lawyers and advocacy groups has been very effective in influencing successive governments with regard to refugee policy. And we can expect these groups to make an all-out effort to block the passage of this legislation because if it becomes law, it could have serious implications for the income of many of them. The committee will no doubt be presented with a wide range of sometimes very detailed arguments from refugee lawyers and advocacy groups as to why the various parts of the legislation are not fair or do not meet our international obligations. I believe that the provisions of Bill C-31 will in fact make the system much fairer than in the past by substantially reducing the time required to approve claims that have merit, because the system won't be clogged up with people who have manifestly unfounded claims. The system won't be perfect. It's quite possible that there will be some genuine cases that fall between the cracks. But bear in mind in this regard that Canada is by no means the only country in the world where people seeking asylum can apply, and they have many other options if Canada does not accept their claim. As for our international obligations, I believe these will be met under Bill C-31, but I'd also point out in this regard that when the UN Convention on Refugees was drafted 60 years ago and updated with its protocol in 1967, many of the features that characterize the movement of asylum seekers today, such as large-scale people smuggling by criminal organizations, passage through safe country by asylum shoppers looking for greener pastures, and claims made by nationals from safe countries such as the United States and Britain, many of these challenges were not envisaged by the drafters of the Convention of the Protocol. While as I have mentioned, I believe that the legislation does indeed meet our obligations under the Convention, I think the latter needs updating and revision to bring it in line with conditions that exist in the world today. And more than one political leader in other refugee-receiving states has suggested that their country withdraw from the Convention in its present form. I'll just mention one comment. Tony Blair, the former British Labour PM, in his memoirs published in 2009, said the Convention was written in response to the horrors of World War II, helped create a system that is completely unrealistic in today's world and utterly incapable of dealing with the massive numbers of asylum claims now being made. And I can quote you other leaders who've said other things. So if you receive lectures on those opposing Bill C-31 to the effect it fails to meet our international obligations, I'd point out that it probably does meet our obligations, but second, in any event, it's questionable whether we should feel bound by a convention that's very much out of date in some respects. With regard, Chairman, to the specific provision of C-31, I'd say they're well thought out. They address many of the problems that affect the current system. It makes sense, for example, to put in place an effective procedure for designating safe countries of origin and having expedited processing for nationals of such countries. It makes sense, no sense to allow our system to be clogged up year after year with hundreds of American asylum seekers, along with smaller countries from some smaller numbers from some such countries as Britain, Australia, France, Sweden, Germany, etc. Virtually nobody else in the world gives serious consideration to nationals of countries that clearly do not persecute their citizens. If I have any criticism of the bill, it's that it does not go far enough in some regards. In addition to designating safe countries of origin, for example, we should also establish a list of safe third countries. Until now, we've only identified the United States as safe third country, and there's no reason why others, such as the United Kingdom, France, and Germany, should not be given similar designations. In the time I've been allotted, I won't attempt to comment on each of the major changes proposed in the legislation, but regard them all as essentially sound. And I would point out that while we at the Center for Immigration Policy Reform support these changes, this doesn't mean we agree with the government on all policy areas of concern to us. In fact, we disagree quite strongly with the government on a number of key issues in the area of immigration policy. As a general comment, I also wish to say that Canada should return as much as possible to its original intent of being a country of resettlement rather than first asylum. We resettle well over 10,000 refugees every year from overseas, most of whom have been screened by the United Nations and are determined to be genuine convention refugees. Most of the asylum seekers who come here to make claims could have applied abroad, but if they don't have a good case for such a claim, they know they're much better off coming here first, since it's common knowledge they are likely to be able to stay here for years and receive generous public assistance, even if their claims are found to be without merit. In conclusion, Chairman, I would point out that while critics of Bill C-31 will argue that its passage would be a step backwards by Canada as a compassionate and welcoming country, I do not believe this is the case at all. We'll still be one of the most generous countries, if not the most generous country in the world, in terms of welcoming refugees, and I think we will have made major strides in terms of reassuring Canadians that we can create an effective, fair, and efficient system that is not open to widespread abuse. Thank you.
Thank you, Mr. Collicutt. Mr. Schauer.
Thank you, Mr. Chair, and good afternoon, members of the committee. I have provided you with two written briefs. The first deals with the bill's changes to the refugee claim process. The second addresses the policies underlying the anti-human smuggling provisions of the bill. There is a detailed biography in the first package. You will see that I have worked as a lawyer representing refugees. I was a member of the Immigration and Refugee Board for more than 6 years deciding refugee claims. I was then the chairperson of the Immigration and Refugee Board for 3 years, which is a managerial perspective on managing the resources of the refugee claim system. And finally, I've been an academic studying refugee systems and the international protection of refugees. In making a recommendation, I want you to know that I view the refugee system from all four perspectives. Certainly, I do not view myself as a member of any lobby in any particular direction. My fundamental allegiance is to the Canadian refugee system that makes decisions that are correct, fair, fast, and efficient. In the time allowed, I will address only three aspects of the bill: the short time limits of the refugee claim process, the lack of an appeal for some claimants, and the government's deterrent strategy for the group arrivals. My first brief includes a summary analysis of Canada's refugee system. It provides a brief description of the current system, some of its flaws, some of the reforms recommended by Bill C-31, and 4 recommendations that come out of that. In regard to the refugee claim process itself, I must say candidly that the time limits are simply too short and will undermine its fairness and its efficiency. Refugees will not have a realistic opportunity to tell their story. A 15-day limit for claimants to file their basis of claim form is simply not enough time. In my brief at page 4 and 5, I outline all of the steps that a refugee claimant has to take in order to file that form. Please imagine a refugee claimant who arrives at Pearson Airport and makes a claim. They do not speak English. They know nothing of the city or Canadian culture. They don't know where to live. They don't know how to use public transport, how to use a cell phone. They may have a cell phone, very little money, and they don't understand the refugee system. Within 15 days, they're expected to find a competent lawyer, see if they can get legal aid approval, instruct the lawyer appropriately, for the lawyer to draft through an interpreter the information and deliver it to the Immigration and Refugee Board. The result of a 15-day limit, in my view, will be more unrepresented claimants and more mistakes in the written form itself. Poorly drafted and incomplete statements make more work for the board member. Members depend on accurate information to prepare for the hearing. Poorly prepared hearings waste hearing room time and induce mistakes. I recommend that you grant 30 days to provide the written statement to the board. It is a modest gesture with dramatic results. For claims inside of Canada at the CIC office, there's a different procedure. I refer to it in my brief, and you may ask me questions about it if you wish. For an appeal to the Refugee Appeal Division, it is 15 working days to file and complete the appeal. Once again, it is simply not enough time. We cannot assume that it will be the same lawyer to represent the claimant at the appeal. Some claimants are already unrepresented, and candidly, some claims are lost because of poor legal representation in the first place. Under our current system, the time allowed for judicial review applications is 45 days. It has been the experience of counsel over many years that that is not enough time. By contrast, the Refugee Appeal Division members will have 90 days to make their decision. So I'm telling you that 15 days, in my view, is far too short. I recommend 45 days in order to file and complete the appeal. Again, you can ask me questions about that. For the designated country of origin claims, hearings are scheduled for 30 days after delivery of the claim form. This is an insufficient amount of time for claimant and counsel to obtain and deliver the evidence. The most important evidence is claim-specific. It's usually located in the country of origin, and it's often difficult to obtain. In addition to that, medical reports, psychological reports are often by far the most germane evidence for the board member to consider. I think you would all understand that it's not possible to obtain those, particularly psychological reports, within 30 days. If the evidence is not available, the results will be either adjournments of hearings, which is inefficient, or unfair decisions based upon incomplete evidence. I recommend that we return to the Balanced Refugee Reform Act, which allowed 60 days for the DCO hearings and 90 days for regular hearings. The Minister has said the faster process is necessary to deter fraudulent claimants. In our current system, it's 4 to 5 years to process a claim from date of claim to date of removal, and that is obviously far too fast. This is not a justification, though, for imposing unrealistically short timelines. Claims that are decided in 6 to 9 months are more than adequate to deter manifestly unfounded claimants. For regular claims, 12 months would be adequate. And I can tell you, based on 25 years of experience in the field, claimants, whether fraudulent or not, often invest everything in trying to get to Canada. They mortgage their homes, they borrow money. If those people return to their country in 5 to 6 or 7 months, I assure you, you will not see a second wave of fraudulent claimants from that country. Super-fast turnarounds of 45 days or 75 days are simply unnecessary, and in my view, they will be unfair in the sense that there will be incorrect decisions made. In regard to Section 36, which defines the 6 categories of claimants who will not have a right of appeal, firstly, I applaud the government for implementing the Refugee Appeal Division that has been in the law since 2002 and never implemented. The lack of an appeal has been one of the critical flaws in Canada's refugee system, and it will certainly help to ensure the board's decisions are well-reasoned and reliable. Refugee claims are not easy to decide. The evidence is inaccessible, claimants are fragile witnesses, mistakes are made inevitably by the best of board members, and candidly, I must say, some members fall below that standard. I think you heard Professor Rahag this morning refer to some of his reports. They are definitive reports showing that the individual acceptance rates of IRB members, the variance between the individual weights is unacceptably broad. The unavoidable fact is that for some of the decisions, they are simply not reliable. And the solution to that is to have a refugee appeal division appeal for each one of those decisions. I refer in my brief to why some categories of claimant even are more important that they have an appeal. You can ask me questions about that if you wish. In conclusion, on the issue of fast process, I'll just make 3 points simply. Allow for modestly longer time limits to give claimants a fair and reasonable opportunity to prove their claims. Allow an appeal to every claimant to catch the mistakes that are inevitable, especially with a faster claim process and prompt removals of failed claimants. Those timelines are more than adequate to eliminate fraudulent claims while ensuring fair and reliable decisions. My second brief deals with the attempt to deter group arrivals by way of 1-year mandatory detention, or up to 1 year, and long-term separation of families. I have left the arguments on legality and constitutionality for others. Mr. Kenney has stated that the purpose of these provisions is to deter asylum seekers from using irregular means to seek protection in Canada. The assumption that mandatory detention will deter asylum seekers from coming to Canada in groups, unfortunately, has no basis in fact. Australia imposed mandatory detention on all boat arrivals in 1994. In the subsequent years, the number of arrivals increased, did not decrease, over the following several years. The number of claims as well, the statistics in my brief provide you with those statistics in a chart. They also show the work of UNHCR researchers that show that mandatory detention does not deter asylum seekers. There is a reason why mandatory detention does not work, and there are 4 principal reasons. The first is that there were studies done of the detainees in Australia. The majority of the detainees did not even know about the detention policies. The reason being their primary source of information was the smugglers. Even for the few that did, or not more than few, the minority that did know about the detention policies, they did not believe them. They thought, Australia, this is a country, rule of law, democracy. They did not think it could be that bad.
Perhaps you could wind up, sir.
Okay, thank you. I'll just go to my conclusion then. Let me conclude by saying that it's possible to have, to make fair and reliable decisions in a relatively short period, to catch our mistakes with an appeal, and still remove failed claimants promptly to preserve the integrity of our system, without resorting to harsh measures such as long-term detention and family separation. I welcome your questions on any part of the bill. Thank you.
Thank you to you both for your presentations. Ms. James.
Thank you, Mr. Chair. I'm going to direct most of my questions to Mr. Collicott, but I just wanted to, Mr. Scholey, you had said something about 4 to 5 years was far too fast for refugees.
Did I say fast?
And I just wanted to just to let you correct that and say that's way too long.
No, I think you said it was
said slow.
We'll agree on that.
Okay, I just wanted
Mr.
to
Chair,
correct
did
the
I say
record.
slow or fast?
I just wanted to correct
You
the record.
understood
Okay.
far
Yeah.
too.
Thank you.
Yes.
I just wanted to give you an opportunity
No, I
to
think
correct
you.
that. I'm actually going to, again, direct my question to Mr. Collicott. Welcome back. This morning, of course, we're in hours of debate on this bill, and this morning we had the opportunity to speak with the Assistant Deputy Minister of Strategic and Program Policy and the Director of Asylum Policy and Programs from Citizenship and Immigration. And one of the questions that I asked was, surely Canada is not the only country that will process some claims faster than others. And I just want to understand from your own personal experience what you can tell this committee on the negative impact we will have in Canada if we do not go with this method of processing applications, some of them faster, and move to a faster and fairer processing. system?
The ones who would be processed more quickly, of course, are those from designated countries like the United States, and we've had hundreds every year from the United States. First of all, it clogs up the system with people who are almost never going to get refugee status but are able to stay here for quite some time. It makes it more costly, but importantly, it slows down the process of other people. And many other countries have rapid processing. In fact, some won't even let them cross the border. Denmark won't let someone from a safe third country in. They're stopped at the border. I would frankly support that. I know that would be difficult to get politically accepted, but I think most Western countries now have some way of dealing with people whose claims just don't make sense. And the idea that Britain or Australia or Sweden, where we get a few claims every year, persecute its citizens in any way just doesn't wash, as far as I'm concerned.
Thank you. And you kind of hit the nail on the head. This system is going to crack down on the bogus refugee claimants, and at the same time make sure that those that are legitimate refugees will be able to have their claims heard quicker, faster, and fairer, and get the support of Canada. But it's interesting because when we talk about the reasons, the pull factor, the reasons why people choose Canada over other countries. We have a situation. My riding is Scarborough Centre. It's in this province of Ontario, and as you know, the welfare system in Ontario, that we have a real issue right now in this particular province, where refugee claimants, bogus refugee claimants, can come in, file the application. And the countries that we're talking about are from the European Union, where 95% of them actually literally walk away from their claims, but they're here long enough to start collecting those lucrative benefits. And I'm just wondering what your comments are on this, because I don't think Canadian taxpayers realize the cost to us, the hardworking Canadian taxpayer. It's actually $170 million a year alone for countries, bogus refugee claimants from the European Union. I just want to know what your comments are on that, please.
Yeah, it's very expensive. By the way, he's now deceased, but Jack Mannion, he was Deputy Minister of Immigration and Secretary of the Treasury Board, he estimated before our Senate committee that the whole system cost us several $billion a year. And the kind of problem, I think, is illustrated by a spike we had in Argentinians in 2001. Thousands of Argentinians came in, claimed refugee status at the border, started collecting welfare, took a two-month holiday, and then returned to Argentina. Now, that's an extreme case, but this is the kind of problem. We've had spikes of people from Turkey, from Trinidad, from Portugal, from all sorts of places where consultants learn Canada's a sitting duck in the refugee system. So I think we have to establish safe countries of origin, certainly, and I would recommend also safe third countries. Most of our claimants often come through European countries where they should have made their claims. So we need two things to slow this down.
Thank you. In my first question, you had mentioned some of the other countries that process claims faster in some cases and not as fast in others. And I'm just wondering, in terms of creating a more efficient and fairer refugee system, what can Canada learn from other countries such as the UK, New Zealand, and Australia?
I wouldn't say they've got it all right in all respects. Australia, when it intercepted boats and had them processed overseas, did it because, as one minister of immigration there said, this was after the Iraqi war started, the UN considered that only 10 to 15% were that reached UNHCR camps in Jordan. Said only 15 to 10% should be resettled abroad. The Minister of Immigration said once they arrive in Australia, 97% somehow manage to stay. And there's a discrepancy there. I would say we've got to do as much as we can to encourage people to make their claims overseas. We have a generous system for processing them. The whole problem is letting large numbers of people make claims in Canada.
Do I have more time? Okay, I'll try and be very quick. And I'm trying to go back in my memory because I know that you have been a guest here in this committee on other business. And if I'm not mistaken, you had once said that you had interviewed a number of terrorists or suspected terrorists, and you said 25% of them had actually come to Canada as refugee claimants. Am I remembering that correctly? Or
I
am
didn't
thinking of
interview them myself, but in certain communities, quite a substantial number of the people who had terrorist connections came in as refugee claimants.
So it would be advisable under this bill, with use of biometrics and screening, it's better to identify the person, obviously, before they arrive in Canada and make sure that we stop them from coming to Canada.
Yes, I wouldn't say that biometric screening is going to screen out too many terrorists, because they may not have, but I think it's good for other reasons.
But the basis of this entire bill, that's one of the purposes, is to make sure that we know who applies, who arrives.
Who apply and who arrives, and I like the biometric part. I just don't think that goes far enough either.
Thank you. And
Goodbye. Ms. Sims.
I knew you'd say that. Thank you.
Thank you very much, Ms. Jane.
Thank you very much to both of you for coming and presenting. My question here is specifically for Peter. Peter, that we have seen the statistics from Australia showing that mandatory detention doesn't really discourage asylum seekers. As a matter of fact, sometimes it increases asylum seekers. Maybe not a direct role, but it's obviously evident there. Is there any explanation for why mandatory detention did not work in Australia?
Yes, there is. I gave part of it already, in that asylum seekers don't get the information about what's going to happen to them. And secondly, in terms of the detention, they don't think it's going to be that bad. But the third reason that they gave, and this is the obvious one, is that they are desperate people. I am sorry, but when Mr. Collicott talks about them being in a place where they can claim settlement, for example, many come from Thailand, they come from Malaysia, they come from Indonesia. These countries are not signatories to the UN Convention. Their status there is that they are illegal. If you read it in the Canadian press, there was a story this morning about a woman in Thailand in exactly that circumstance. What can happen to them is this, that they can get a UNHCR registration within 6 months. That does nothing for them. They're vulnerable to arrest, they're vulnerable to corrupt officials, they're vulnerable to criminals, and Thailand and Indonesia and Malaysia will return them to their country of persecution. They do not get sent elsewhere. That's the desperation. That's why so many of them will take the chance on the boat. Some of them won't take the chance on the boat. There are no alternatives, and there are no refugee camps. The refugee camps in Thailand, for example, are only for the claimants from Myanmar or Burma. They're not for other claimants. They do not have good options. It's important to understand that.
And thank you for clarifying that not every refugee is, who arrives can arrive through the resettlement program, and also the fact that not every refugee who's trying to get into Canada is a terrorist just waiting to come and do harm.
Well, let's talk about that resettlement program that was referred to. The resettlement program, please understand, Canada is the second most generous country in the world. We actually accepted about 13,000 just after the U.S. But the resettlement program under the UN Convention was never intended as the primary vehicle for bringing refugees to the country. Even within those refugee camps, there are 3 durable options. The first one's repatriation, the second one is local integration, and only the third is resettlement. We took 13,000. There are over 4 million people in refugee camps. The average amount of time in a refugee camp is 17 years. Let me ask every member of this committee, I'm sorry to be personal about it, but I'm a father with a couple of kids. If I had a choice where I'm stuck somewhere and I'm illegal, and I can either go to a hellhole of a refugee camp where I'm going to be there for 17 years, if I could find a way to get my kids to a safe country, whether it's Canada or somewhere else, I know what I could do if I could find a way to do it.
Thank you. Thank you very much. And I'm going to move to a different aspect of the questioning. Why is an appeal so important if there is an application for judicial review? And what is the difference between the two processes? If you could explain that to us, I would really appreciate it.
Of course. And as I say, I repeat again, I'm delighted that the government has implemented the appeal division. It was necessary. The judicial review application, first of all, it's only application for leave for judicial review, which is permission to do judicial review. Only 14% get the leave application. And once again, Professor Rahag's statistics show that there's a tremendously wide variance in those leave application decisions by the federal court judge. But even if you get that leave, federal court is making a determination on basis of issues of law. And I know there are some lawyers here at the committee, so issues of law can include egregious findings of fact. But they're deferential to the board. It is not an appeal, and all they can do, their only power, is to send it back for another hearing. The Refugee Appeal Division was termed it's universal access, so everybody gets their appeal considered. And if there were fundamental errors where it's obvious on the evidence that they are refugees, the Appeal Division has the authority to overturn the decision. So it is intended to catch the mistakes, to put it simply.
Do I have a few more minutes?
You do.
Okay.
Yep.
Okay. What is the difference? Because there seems to be a lot hanging on this in this legislation. What is the difference between a refugee claimant who arrives at an airport and one who arrives in a group on a boat, if they both have used fraudulent documents to get to Canada? Because to me, a refugee is a refugee, whichever way you arrive. But this piece of legislation definitely differentiates between the two. So over to you.
When they arrive, they're not refugees, they're asylum seekers and they're refugee claimants. However, we do know this from the boats. We cannot, if someone arrives in a group, we cannot make any assumption about the merits of their claim, whether or not there's a greater or lesser possibility that they're a refugee. To give you a contrast, when the first boat arrived from Sri Lanka, the acceptance rate for Sri Lankan claimants was 76%. 10 years earlier, with the 4 boats from the People's Republic of China, the acceptance rate was less than 5%. So we can't draw conclusions just because it's a group arrival. The second thing that you can't draw is any inference that it is an increased threat to Canada one way or the other because they're in a group. It is not a security threat. What is the difference? The only difference is that, quite frankly, it's the person that arrives with fraudulent documents that they manage to come through Vancouver Airport probably is that they had more money, so they were able to buy better quality documents so they could get to Canada. But in terms of threats to Canada, in terms of merits of the claim, there is no difference.
Thank you very much.
Thank you. Mr. Lamoureux.
Mr. Troy, my questions are for you. And, listening to Ms. James, I think about 4 or 5 times she kept on using the word bogus refugee claimants. And I know there is a difference. And I'm wondering if you can expand on the government's using the term bogus refugees.
Certainly. And I take bogus refugee to mean a fraudulent refugee. And by that, I mean someone who knows they are not a refugee and they're coming to Canada anyway. In other words, they are abusing Canada's refugee system. I think where the confusion occurs is with this notion of failed refugees. If someone's claim is refused, it does not necessarily mean they are bogus. They may very well have come to Canada with the belief that they're refugees, genuinely seeking protection, but in actuality, they're refused. And a good example of this would be the many Mexican claims that came over the last 5 or 6 years. A lot of those claims were refused not because the person didn't have a fear of either drug lords or someone else. A lot of them were on technical legal reasons within the definition. The conclusion by the board of the federal court was there was adequate state protection for them, or in other instances they thought there was another part of the country they could go to be safe. But the issue wasn't, in many cases, the credibility of the claim was accepted. It was within the technical definition of a refugee. In my view, those people are not bogus refugees. We may have a difference of opinion with the minister and others, but I think it's not only unfair to characterize them that way, in a way it distorts the issues in trying to understand an effective system that will let real refugees be here and quickly identify non-valid claims and remove them.
It's a poor way to label, actually, was what I find. But in regards to, a big part of this is all about fraudulent claims. Are there thoughts or ideas that you might want to share with the committee in regards to how you would deter these fraudulent claims?
Well, I've already mentioned to you this notion of determination within 6 to 7 months. I accept the concept of a designated country of origin. I accept the notion that there are some. This is somewhat. I mean, not everybody will agree with me in terms of the so-called advocacy community, but I think it's possible. I think what's important is that you can deter the claims. You can do two things. I'm saying you can have your cake and eat it too. That you can have a well-reasoned decision, you can have a well-reasoned appeal, and when they're not refugees, you can promptly remove them from the country, and certainly if you do it in 6 to 7 months, as I say, I am very confident that you will deter fraudulent claim flows.
The other thing I would ask is, in regards to detention centers, we've had the minister refer to them almost like motels of sorts, and I wonder if you can share any sort of experience or knowledge you might have about detention centers.
Well, I can share both my experience but also the research that's contained in the brief that I provided to you, this second brief. And essentially what we know is that there are only 299 spaces available for detainees under the federal program across Canada. Most of them are full all the time. So the principal concern is if there's any significant group that comes, as happened with the 2 boats on the West Coast, they will be referred to provincial penal institutions. And they're not detention centers, they're penal institutions. There will be other witnesses that appear before you, but you will have the briefs to show you that they're being placed in penitentiaries where the staff is used to dealing with criminals. They'll be in with mixed criminal populations. Now, one of the exceptions to that, they did not put the mothers, the parents who had children with them. They kept those in the detention center in Burnaby. But again, my concern as a Canadian is thinking about this. These are people who are refugee claimants. They may or may not be refugees, but we know a significant number of them may be victims of torture. They may have already gone through hell in civil wars such as Sri Lanka. And the issue is, if people like that, not speaking English, being easily separated out from the population, are being placed in penal institutions, I feel there is a significant policy concern, and that has to be considered.
Okay. Lastly, if I can, Mr. Chair.
Well, you've got about 10 seconds.
UK and Australia, their detention centers, is Canada doing well to look at those as models?
No.
Yeah. Mr. Dijkstra.
Mr. Schaller, you referred earlier to say that the detention system that Australia implemented. Could you tell me where you quoted your facts and figures from and the date that you quoted those figures from?
Well, they're all in my brief with footnotes, and you'll have the exact numbers and include. There's also a quote from, I forget his name, but from about a year ago, the current minister who has stated and retracted the policy saying it was a bad idea. But well, it's all in the brief, sir.
Great. I'm going to look forward to looking at your briefs, because in March of this year, the United Nations actually did a report on what was happening with respect to asylum seekers, and the only country that actually saw a decline in asylum seekers was Australia. The UN actually stated that the fact that there was a reduction is because of the issues around the detention policy that Australia passed, therefore seeing the decline, therefore seeing asylum seekers going to another country. Sir, I'm not arguing with your point.
Let me say this, that one of the quotes in there is from Alice Edwards, who is the principal researcher for the UNHCR. And
I'm quoting from a report directly from the United Nations. I can give you the report. Asylum levels and trends in industrialized countries said the numbers heading to Australia in 2011 fell 9%, from 12,640 in 2010 to 11,510 in 2011. A decline, sir. You suggested there was an increase. I'm just stating for the record that there was actually a decline.
In regard to the increase in numbers, the mandatory detention policy was put in place in 1994. You will find the chart in there, the significant increases each year. It stopped in 2001, and there was a decline.
I'm just pointing out that in 2011, over 2010, there was a decline.
Yes,
the UN points to the detention as a reason, a potential reason as to why the decline has taken place. Well, I'm only asking you to acknowledge that, not to agree with it.
What I'm saying is
2010,
what caused
2011?
the decline in 2001 was the Pacific solution, when they actually kept all boats from arriving in Australia and sent them to Nauru.
Well,
then they achieved it. But, sir, as a reasonable
I'm just
thinker-
asking you, I'm just stating for you. I'm asking
I'm
the
not going to-
questions, right? Like,
Stop the
he may
clock.
not,
Stop the clock.
Mr. Schauler may not like.
Well, we seem to be getting into a debate between a witness.
Get into debate.
Sir, we seem to
I
be
stop.
getting into a debate, and could I suggest that both
course.
of you move on to something else?
Sure.
It appears you disagree, and let's
happy to
leave
do
it at that.
I'm going to turn my time over to Mr. Opitz. The one point I want to make, sir, is if you're going to bring up an example of how would I treat and bring up my children versus what would you do? I certainly feel that those that sit in, I hope that my children understand that those sitting in a refugee camp for up to 17 years deserve to be treated fairly as well, and not to say that the best way to do it is to smuggle someone to the country and get in quicker than someone who's had to wait that long, as you suggested. So it's just a personal observation, but disagree with you on that. Mr. Opitz?
Sean, go ahead.
3 minutes.
Minutes? Okay, good stuff. There's also the problem of...
4 minutes.
Oh, okay. There's also the problem of human smugglers in that this is not a safe way of passage. These are guys often tied to organized crime, often intending on trafficking people or making money from smuggling. Oftentimes, smuggling and trafficking become one and the same thing, and that puts people in dire circumstances. And there are incidents of a lot of these smugglers out at sea. If they get caught, they oftentimes throw people overboard. And it's a very, very dangerous pursuit if they do that. And I think everybody's in agreement on that, and that's oftentimes not the safest way for people to try to come to Canada. Also, in response to my friend, not everybody trying to come to Canada is a terrorist, but there sure are a few. And it only takes the one guy that is determined, gets here, uses the refugee system to do that, and causes a tremendous amount of harm to this country. And I think there have been examples of that. So we have to be very, very careful in that instance. And as well, some people do queue jump by using the refugee system, and they are bogus or fraudulent refugees, and that clogs up our system. But Mr. Collicott, you used a term I thought was very interesting. You used the term asylum shoppers. Could you expand on that term, sir?
Well, the example I used was the 152 people who arrived off the coast of Newfoundland in 1986. I was involved in that because I'd just been High Commissioner in Sri Lanka and I had just returned. They had asylum in Germany. But they heard, I think it's reasonable to assume they heard that there were much more better benefits in Canada. And basically, it's people who travel through countries where they could have made claims. I mean, their primary objective is presumably to reach safety. But in fact, their real objective is to go to a place where they can have a lot of benefits. Safety is not their first concern. So they will move on to find a country, and Canada is probably the most generous in terms of benefits. So let's get to Canada, even if it's the hardest to reach geographically.
Yeah, absolutely. And I know that there were cases, and there were reports earlier on, or witnesses had said earlier on, that many asylum seekers who had come here boldly said to CBSA they came here for the money. So, but our laws have to process them through at that point in time. In turning to detention, what is your view on detention, sir?
Well, first of all, the term detention is sometimes equated to imprisonment. And in some cases, Mr. Scholler pointed out, people are kept in penal places. The recent influx of Roma people from Hungary, in fact, are probably mostly kept in hotels, and the space available for Canadian-born who may need assistance is limited. Detention is an interesting term for asylum seekers because it's sometimes considered that, well, they're innocent and proven guilty, why should they be held? It is not like a prison. They're free to leave any time they want to drop their claim and leave. They're only being told, if you want to come and stay in this country, we have to put you in a holding place till we decide if you deserve to be kept here. So I believe that widespread detention probably does make quite a bit of sense, particularly in the mass arrivals, because we're overwhelmed with numbers. We cannot screen them quickly. They pose a particular problem, not just in terms of large-scale criminal gang operations and possibly terrorists, but also in terms of sheer numbers. It draws resources off all sorts of other areas.
Thank you. Monsieur Zucker.
Bonjour. Et je vous remercie.
Good day. Thank you for being here. My first question is for Mr. Collicott. How would you define a new legislation that would give the minister the permission to designate an irregular arrival? This same minister designates a safe country. This very same minister would be designating clandestine or immigrant, and the grounds for detention. There are so many ways in which a minister could get involved at any point in the enforcement of the act and in overturning any decision from officials. Do you think that from a structural point of view, this will mean we will be able to unclog the system, whereas systematically all politicians seem to be able to get involved, that these politicians could get involved and put pressure on the minister?
A good question, Mr. Giguère. I think it certainly, the new act does give the minister more authority, but it brings us in line with what most other countries do. I mean, one of the objections has been to having public servants do the initial screening. Instead of having an independent body. There will be reviews by an independent body, but you're going to get much more continuity and consistency in the decisions. We'll be doing what other countries do, and I don't know of any part of the increased authority, and you're quite right, there will be increased authority for the minister, that I have difficulty with. I don't know if there's some specific aspect you want to ask about, but it will simply bring us into the 21st century where we've taken a long time getting there, and that's why our system's so dysfunctional.
Je vous remercie beaucoup.
Thank you very much. Mr. Scholler, the minister says that foreign nationals, designated nationals, are queue jumping. Can you explain to us what a real wait line would be for refugees, what the queue would be?
Well, in my view, it's clear I am disagreeing with some of the people here at the committee head, there is no queue. And the reason that there is no queue is because, first of all, under the UN Refugee Convention, Mr. Collicott referred to it that Canada supposedly didn't know what they were signing on to, which I think they understood very well what they were signing on to. And what the Refugee Convention allows for is for someone to come to a country that is a host country under the Convention and seek protection. That is the core part of international protection. That is what occurs. There is no queuing up. There is no principle anywhere in international law that suggests they go to a refugee camp. I've already explained some can't even get to it, but in any event, there is no queue. That's not how it works. They come to a country, and there is this notion of a safe third country. Mr. Collicott referred to it before. However, Mr. Collicott unfortunately referred to it as though it's arbitrary. Safe third countries are where there's an agreement between, as we have with the United States and Canada. Canada, candidly, would love to make an agreement and has had to consider agreements with countries in Europe, but they're not prepared to make those agreements because they've got to be two-ways agreements. But essentially, there is no queue in law or in fact.
Très bien. Et je vais...
Very well. I'll be asking a similar question now. Insofar as we have this new legislation under which the minister could designate irregular arrivals, this is a decision-making authority as to whether yes or no they should be considered irregular refugees. When it comes to the host countries, the minister at the end of the day is the one deciding whether a country is considered a safe country or not. Again, the minister designates everything that could be considered humanitarian conditions. The minister may intervene politically to consider certain refugees on a humanitarian basis. Do you not find that this kind of encroachment and partisan encroachment, opening the door to lobbyists, would you not say that this would make this legislation very hard to enforce?
I don't refer to it much in my brief, but there are other briefs presented, and certainly from the legal review, there is a combination both in terms of the designation of countries of origin and designation of foreign nationals as group arrivals, and in both situations the concern is the criteria for the designation are extremely broad, and secondly the limits on those powers or the discretion is virtually non-existent. There is some within the designated country of origin, but not much.
Thank you,
so
Mr. Scheller.
So the concern is it's too broad and too vague.
Thank you. Mr. Menegakis.
Thank you, Mr. Chair. Welcome, gentlemen. Thank you very much for your presentations here today. This bill, C-31, the intent of the bill is to help facilitate the process, make it faster. The intent was not to penalize legitimate bona fide people that seek our assistance. With the new measures in the bill, the time to finalize a refugee claim, a legitimate refugee claim, would drop from a current average of 1,038 days to 45 days for claimants from designated countries of origin, or 216 days for all other claimants. So we can imagine what a huge benefit this is to somebody who is really seeking and needs asylum from persecution in their own nation. That's a big positive, in my opinion, of this bill. Mr. Collicott, in your opinion, because before I ask my question, let me preface it by saying this: human smuggling seeks to circumvent the proper channel. In your opinion, are human smuggling rings becoming more elaborate?
I think they get more sophisticated. The more barriers you set up against them, the more complex they can sometimes be. I think the sheer numbers, though, coming in by boat pose a major problem. But they've been using forged documents and fraudulent documents for years and years. Mr. Scheller mentioned that we agreed originally with the UN Convention. In fact, though, we didn't know what we were in for because these problems hadn't developed. Human smuggling was estimated by the International Organization for Migration as an $18 billion a year operation. That was 10 years ago. It's probably much more than that now. There's a lot of money. The people say a lot of drug dealers are now switching to human smuggling because the penalties are less. So it's a huge problem. And it doesn't just apply to irregular arrivals. There have been estimates of 70 to 90% of people coming in by air on flights as being human smuggled. The problem is it's very difficult to pursue each one of those cases. But human smugglers are very heavily involved in the movement of asylum seekers, as distinct from people that we take from camps. And by the way, Mr. Scheller mentioned 4 million people in camps. The UN doesn't consider most of those need resettlement. They need to be given temporary protection until they can go back to their homelands. The number they consider need to be resettled is still significant, but it's much, much smaller. It's in the hundreds of thousands at most.
Well, certainly they've become money-making operations, and in many instances sophisticated money-making operations. But I'd be interested to know, from your time as High Commissioner to Sri Lanka, Ambassador to Syria and Lebanon, and Ambassador to Cambodia, could you tell us about the human smuggling operations in those countries?
There were not cases I can recall of major human smuggling. Well, Sri Lanka, the boats hadn't started yet. And it's the irregular arrivals that a lot of this bill is aimed at. they began to increase in number in Canada's case, first in 1986. Australia, as Mr. Scholler mentioned, one of the main reasons why there was a dip in claims in Australia was that the John Howard government instituted the Pacific solution, where they simply didn't let people land. They processed them overseas. They considered their claims. They accepted some. They turned down others. Kevin Rudd, when he became Prime Minister in 2007, said, "This is too harsh. We'll let them all land." Well, hundreds arrived, and that was one reason why he lost the leadership of the Labour Party and the Prime Ministership. Not the only reason, but that was one of the major ones. So most of the human smuggling has been, larger numbers have come by air, 1 or 2 at a time. But these big operations really do test the system and create special problems, and I think you do need legislation to deal with them. I hope eventually we can have something to deter all human smuggler people, but when you come in 1 or 2 at a time, that's not easy to identify.
Thank you. Is that about mine?
You are, sir.
Thank you.
And I think that we are going to be short of time because of the vote tonight. So, Mr. Schaller, Mr. Calicott, thank you to both of you for coming and making your presentations to us. Thank you very much. We will suspend for a few minutes. This meeting to order. Order, please. Take your conversations outside. Thank you. We're going to call the meeting to order. We have 2 witnesses for the second, well, it won't be an hour. We will end this second round at 5:20 because of the vote tonight. And the last session will begin around 5:20 as well. So we have 2 witnesses. We have Julie Taub, am I pronouncing your name correctly, who is a immigration and refugee lawyer. Good afternoon to you. We have the second witness is two people from the Canadian Civil Liberties Association's Noah Mendelsohn, yes, who is the director of a quality program. I didn't say your last name. Aviv.
Now you got the whole thing.
Yeah. Well, Natalie DeRosier, who is the general counsel. Good afternoon to you. So,
Thank you.
Each group will have up to 10 minutes. We'll start with Ms. Taub.
I'm just wondering if everybody got my brief bio and background information.
Yes.
And if they, because I don't want to dwell on that. It just suffice to say that I am a former member of the Immigration and Refugee Board and an immigration and refugee lawyer in Ottawa, exclusively since 2001. Previous to that, I was on the Refugee Board. I think it's important just to very briefly refer to my personal background so you'll have a thorough understanding that I have not only professional but personal, in-depth knowledge of what a refugee is. I am a sister of a child Holocaust survivor, and I am a child of my late parents who were Holocaust survivors. So I know what it is to be a refugee. My late mother and my sister, who is much older than me and still alive, survived Ravensbrück concentration camp. My late father escaped a labor camp in Germany and got back into Czechoslovakia and hid out in the Tatra Mountains during the war. He managed to save his elderly parents, and for some time he hid with the partisans in the Tatra Mountains. Those were the resistance group. And finally he was hiding in a bomb crater and was rescued by the Soviet Army. So from that experience, I wish to address the committee today. I'm here to support Bill C-31. I might also add that I have represented hundreds of refugee claimants since 2001. I have had claimants from Sudan, Nigeria, the Democratic Republic of Congo, Eritrea, Djibouti, Somalia, Ethiopia, Uganda, Lebanon, Syria, Egypt, Morocco, Algeria, Colombia, Venezuela, Haiti, Cuba, and even Mexico. That list may not be exhaustive. I certainly didn't have a chance to review all the clients I've had in the last 12 years, or 11 years. Just recently, I've had some hearings for Eritrean clients in January and February, which were outstanding from late 2009 and 2010. And I have at least a dozen outstanding refugee claims from 2010 that still haven't even been scheduled for hearings. So I support the accelerated process that the minister has brought forth, because waiting 2-3 years to have a hearing is completely ridiculous. Now, as we all know, and I'm sure you all know, that the Holocaust was the basis of the 1951 International Convention and its updated protocols in 1967. This convention was not drafted to serve an industry of criminal smugglers, of people who may or may not be genuine refugees, or to facilitate asylum shopping. That is, which country can I get to that will give me the most generous benefits and the highest acceptance rate. And it was not crafted or drafted to even consider claims from citizens who come from established democracies. I'm not talking about those where the criteria qualitative and quantitative criteria set by the minister can vary from year to year. I'm talking about established democracies which have evolved over the centuries, such as the United States, New Zealand, Australia, the European Union countries, and even Japan since World War II. I do not believe that the convention, those who drafted, had this in mind, that people, U.S. citizens, would be considered for refugee claims. The current system that we have, as far as I am concerned, besmirches the memory of Holocaust survivors. The very thought of treating on equal footing somebody from the United States or Britain and Sweden with refugees from Darfur, with refugees from Rwanda, with women fleeing Sharia law or genital mutilation, and I have represented them all, on equal footing with somebody from the United States is just outrageous as far as my personal opinion goes. And then there's also the issue of Christians who are now fleeing massacres in certain Islamic theocracies. Those are the real refugees. The over 100,000 Karen people sitting in Mae Sot district of Thailand in UNHCR refugee camps. There are the real refugees. And I have personal knowledge of the My Lai refugee camp because my daughter, now a physician, was a fourth-year medical student and went and volunteered in the Mae Sot Medical Clinic in northern Thailand. That Mae Sot Medical Clinic services that sprawling, horrible refugee camp of over 100,000 Karen people. Through her intervention and my intervention, we were able to bring one Karen person who had been originally turned down, whose aunt and uncle lived in Ottawa, Aso Gay, to Canada. The only way someone could leave the refugee camp was to have an appointment at the clinic. She brought in Aso Gay into the clinic twice. I sent her the questions. I told her to interview her, and then she was interviewed by CBC. And of course, Immigration Canada heard that, and they reversed this decision, and Aso Gay was brought to Canada. Now, when there's criticism that there is designated countries of origin, I have no issue with that. And I have no issue with safe third country agreements because, believe you me, Jewish refugees who were trying to flee Europe would not have shopped around. They would have gladly taken any country, any first country they could have stepped foot in, and made their asylum claim there, and they wouldn't have traipsed it around the world finding a country of more generous benefits. And as I speak now, anti-Semitism is on the rise in Hungary. And since I originally came, well, I was an infant born on the Hungarian side of the Czech-Hungarian border at that time, I have friends in Hungary, and one of them being Peter Feldmayer, who is the head of the Jewish community in Hungary. Anti-Semitism is with this new right-wing government, is almost state-sanctioned. And he said to me, the young Jewish people, his children included, are leaving. But they're not making refugee claims. They're going to one of 26 other European Union countries. And they're not coming to Canada. They're going to one of the other countries or to Israel. But you don't have masses of Jews coming from France, where they're being daily attacked, making refugee claims. They're going to other EU countries. When they say that there's not enough time to make a refugee claim in the 45 or 90 days, et cetera, that the minister is trying to accelerate the claims to, under the current system, claimants have 28 days to submit a personal information form. And all the hundreds of claimants I have represented, we've never had an issue getting the personal information form, which is the basis of the claim, into the Immigration and Refugee Board. The issue has been waiting 2 years to get a hearing. That's where the issue is. And having accelerated process for claimants from designated countries of origin is not an issue, because we're simply implementing measures similar to those in many EU countries. For example, some countries in Europe, and I have a whole list of all the countries. Just a minute. For example, in the United Kingdom, for those coming from what's considered to be safe countries of origin, it's 10 to 14 days. They fast-track the claims. In France, it's 15 days. In Germany, it's 2 days if they come from countries such as Canada, the United States, Australia, and New Zealand, and they don't even accept refugee claims from other EU countries because, as you are fully aware, a citizen of one EU country has the absolute right to go and live and work in another EU country. And you may say, if we're going to refer to the Roma, well, there might be an impediment because of language. Well, when they come to Canada, there is the same impediment. They speak Hungarian or Slovak, depending where they're coming from.
Perhaps you could wind up, Ms. Taub, please.
Okay. Now, the one exception I have to supporting the minister is that he is expecting faster decisions to accelerate the overall processing times on refugee claims. However, he has just cut, or is cutting 1,500 CBSA positions. Now, this is counterproductive to an accelerated refugee processing time because they're the intelligence gatherers. They're on the front line who meet the people when they come in. So how does he expect to expedite and accelerate if, on the one hand, he taketh away the very officers who are supposed to help with the processing?
Thank you, Ms. Taub. We'll have to move on. Ms. Mendelson-Aviv?
No, Ms. Desrosiers.
Ms. Desrosiers, thank you. You have up to 10 minutes.
Oui. Merci beaucoup. Je vais faire...
Yes, thank you very much. I'll be making my presentation in both French and English, so I'd invite you to put your headphone on. Our association, the Canadian Civil Liberties Association, has been involved in the protection of civil liberties in Canada for many decades. And this is the reason why we are here before in this context in which we are appearing before your committee. And it is a pleasure to share our concerns with your committee. My presentation is divided in two parts. I'd like to refer to the constitutional issues in this bill, and I have 3 points to raise in this regard. Of course, the association supports any improvement to the process of defining refugees. We support that approach, and we also support the use of criminal law to deal with human smugglers. Our point here is to say that in wanting to do this in this bill is overreaching and will cause significant constitutional problems for Canada and should therefore be revised in that context. The second part of my presentation would be to invite you as parliamentarians to reflect on your role here in assessing this bill.
There are three things that I want to suggest. I'll speak obviously from a civil libertarian position. There are three things in this bill that I think transform some constitutional law concepts, and I will invite you to worry a little bit about this. To worry that indeed in doing so, in achieving, as you said, some good objectives, there may be some drawbacks that will affect all Canadians. And the first one will be what I describe as the mandatory detention for the group designated people. And the three things that I want to say here is this. First, this is a group detention. It's a group assessment. In Canada, we tend not to agree with group assessment. Mass arrests are wrongs. Mass detention are wrongs. And I think it's important to view that in this. It goes against some of the fundamental issues that we have in Canada, which is when you're going to make a decision that's going to deprive someone of his or her liberty, and I will go back to Mr. Collicott's argument here, you have to have an individual assessment as to whether there's a good reason to do that and whether indeed the person poses a risk. So if you read in our brief, the description of what the law is on arbitrary detention, which requires an individual assessment of whether the person has or is connected to crime, this bill doesn't do that. The reasons why the minister will be able to designate a group have to do with administrative convenience or administrative demands, or because he or she suspects that maybe there will be some smuggling. But it's never connected to the individual members of the group. And that will be a flaw in constitutional law in terms of arbitrary detention. The second point, I think, so there is group detention, group assessment of blame that is inappropriate. The second one, I think, is this detention is without judicial supervision. There is no possibility of judicial validating or judicial vetting of the detention for 12 months. This is a denial of the right to habeas corpus. You cannot do this. This is dangerous. It's dangerous because if we start doing this, if we start saying this group does not have the right to habeas corpus, this group is denied the possibility of having their detention, the legality of detention vetted by a judge, I think we risk the run, not that this government will do it, but that other governments may decide to designate a group and deny them the right to habeas corpus or the right to have their detentions validated. In Sharkawi, as you will read in our brief, the court has said, 120 days of detention for people suspected of terrorism without judicial review is wrong, is unconstitutional. There's no doubt that for asylum seekers, where there is no evidence of link to criminal activity, this will be viewed as unconstitutional. I want to provide also the committee with a reflection that the bill already, if there are administrative problems, and they will be, this is what currently the Act says. And I think it's important to say that it is possible now. In our current immigration law, it doesn't have mandatory detention, but if a person must be seen by an independent decision maker within 48 hours of being detained to determine whether there is a need to keep them locked up, in a way, I think what we have in the bill is that we certainly are ensuring that people will show up for their hearing. They can be detained if there's a risk that they will not show up, if they present a risk to the national security, and if their identity cannot be ascertained. So the current provisions do provide for what for the administrative necessities that are now in fashion. Mon deuxième point, my second part, is to insist on why, as parliamentarians, I urge you to reflect on this bill. Certainly, I think the bill also, and just to complete the idea that there's also a discriminatory aspect of this. Not only will people that are in the designated group be detained for 12 months without judicial review, but thereafter, their ability to seek a permanent residence is delayed. And even after they have been found to be a legitimate refugee. In my view, there's no reason in Canada to make a distinction, to make a distinctions between some refugee people and some others. Once they have received refugee status, they should be treated the same. They should have the same ability to become permanent residents. And the reason to do so is that demanding to permanent residency is indeed part of integration to Canada. Once they are, recognized as refugees, they should be treated equally. In my view, this will raise some issues in terms of violation of Section 15 of the Charter, and I think we should be worried about that as well. As parliamentarians, why do we think that indeed you should worry about this bill? And I'm speaking to you as parliamentarian. This is a bill where I think there's a large expansion of the executive powers here. And I think it's incumbent on parliamentarians to recognize what is their role here, is to ensure that indeed this is not going too far in preventing the executive from being sufficiently bound. In a way, the executive now decides that there will not be judicial review and then says has very little parliamentary oversight on this bill as well. So I urge you to reflect on what is your role as parliamentarians in evaluating this. The deuxième point that I want to make on the role of...
The second point?
We all know that at times it is easy for xenophobic feelings to rise. I am pretty sure that there's no minister of this government that would, order mandatory detention on poor souls arriving from desperate countries. But this projet de loi, this bill is not here only for now. It will be here forever. And indeed, I think once you create the ability, what the minister says is, I may not use this bill, but I want it in my back pocket just in case. But this possibility of designating a group could be done wrongly in the future. And I was going to mention the fact that at times Canada has done some nasty things, has done some things that we're not proud of. Indeed, I think if I want to conclude on this and say, when we imposed the head tax on Chinese immigrants, when we turned away the Komagata Maru ship in 1914, 376 Indians died. When we refused access to the Afro-American farmers during the recession, when we incarcerated the Japanese and Ukrainians, when denied entry to the St. Louis in 1939, and 900 Jewish people were returned to Europe, these decisions were popular. And my fear is that decades later, we unveil commemorative plaques, we offer apologies, sometimes we pay damages and try to alleviate the pain, but it's too late, people have died. And I urge you to think about the possibility that there may be in the future some decision to incarcerate people for 12 months, to deport them in a context, well, we will later on feel very ashamed of what we have done. It's not appropriate to leave all this decision to a minister. It creates too much danger that this power could be abused. I urge you to consider this possibility. Merci.
Thank you very much. You should get out of law and become a politician. You're very persuasive.
But invite me.
You've been persuaded?
No, I didn't say that. I'm the chairman. I'm unbiased. Okay. We now go to the questions. Mr. Opitz, please.
Thank you, Mr. Chair. First over to Ms. Taub. I think we have some similarities in terms of our backgrounds. I know my parents came here at the end of the Second World War, and my dad spent a significant amount of time in a gulag, and my mom was taken to Nazi Germany in forced labor. So when they came to this country, it was a very different time, and where they had 2-year contracts, had to work their way through before they were allowed to actually get entered into Canadian society and integrate in the way that they wanted to integrate. And so, but they did, and they worked hard, and they got through all of that. And your parents, obviously, we've been going through a lot of commemorations recently, and that's Holocaust is one of them. And it's certainly an important factor in a lot of our decision-making, as Ms. Desrosiers has just pointed out in some of those areas. But, ma'am, what impact do you think bogus refugees have on genuine refugees who have to then wait longer? And would you think, what do you think that it makes sense that 25% of those refugee claims in Canada come from the EU, which in fact is more than Africa and Asia? What would you comment on that says about
Well, I am not one of the drafters of the current bill, C-31. Had I been, I would have suggested a third category, safe countries of origin, where no claims would be considered. And I would have included all the countries of the European Union and the United States, New Zealand, Australia, Switzerland, Norway, which is not part of the European Union, and not even consider those claims. By the way, Switzerland has that policy on its books, and most of the European countries regarding these safe countries of origins, they process it in 2 days to 3 weeks. So As I read you the list of countries whose citizens I have represented before the Refugee Board, and you may have noted that none of those countries appear on my list because I won't represent them because I don't believe that they are genuine refugee claimants. And again, I can tell you that from the European Union, I don't know how often I should reiterate it, they have 27 countries. We have 10 provinces, 2 territories. Anybody from Quebec can still go and live and work anywhere in Canada. Anybody from one of those 27 countries has a choice of 26 other countries to go and live and work. And discrimination is not persecution.
Agreed. So in your opinion, with someone who is a genuine refugee and feared returning to their home country, they tend to withdraw or abandon their claims and willingly return to their country of origin. What would you say is the impact of that?
They're obviously not genuine refugees. And then there's this whole issue of people, including some of my clients, I've been quite distressed to learn afterwards, who after being granted refugee status go and ask get a travel document to return to their home countries from whence they fled in fear of their lives. When any of my successful refugee claimants have come into my office and asked me to help them fill out an application for a travel document, I say, where do you want to go? And back to the country they left. I said, are you crazy? I thought you left for fear of your life. Why in the world do you want to go back there? So, after all my years of experience, anybody who returns to their country of origin that they left in fear, I question the validity of their original claim, unless, of course, if there's been a drastic change of country conditions where it's safe to go. But if we're talking about within a few months or even a year or two afterwards and nothing much has changed in their home country and they still want to go back, because I question the validity of their original claim.
And you did make a comment earlier on about asylum shoppers as well, as Mr. Collicott did earlier, because I know that when CBSA officers get some pretty interesting answers, as we found out earlier, like responses like free salary for coming to Canada. Have you been privy to any of those types of answers or questions in your own?
I've had a few calls from abroad, various calls. People are mostly young men who are coming in from some Middle East countries asking me about refugee claims, and that they'll be arriving next month. Can I take their case? And I said, well, how you can't just come in. You need a visa. Oh, I'm coming as an international student, and then I'm going to make a refugee claim. And I try to explain, well, if you're already coming as an international student, you've got stability here, and I tell them the process, finish your degree, work, and then you can immigrate. Oh, no, I can't afford it or whatever. So I think there's quite a bit of abuse going on, just based on calls and people, clients that I have met with whose cases I don't take, and clients who I've represented and then come back and ask for travel documents. I know the system inside out.
People who go to school here for 3 years, depending on trade, they have the Canadian experience class that they can sometimes rely on.
Absolutely, Canadian experience class, skilled workers if there's a certain profession. Then there's a low-skilled level workers. There are many ways to immigrate to Canada legitimately. And I feel that too many people are using the refugee process as a parallel immigration process.
I saw you mentioned 28 days as sufficient time to fill out the initial paperwork.
Yes.
And
I've never missed the deadline of the hundreds and hundreds I have.
Oh.
And we're not looking at 28 days here. And when somebody is leaving their country, they have the intention, they're leaving, they fear for their lives. If they come from certain countries, such as Rwanda, Somalia, Eritrea, often they come without paperwork. But we all know the conditions of those countries. And we can't even expect them to get the necessary paperwork. But nobody will question. A woman who's coming, who is fleeing from a forced marriage or from genital mutilation or wants to protect her daughter from genital mutilation, the board doesn't require paperwork. The documentary evidence is more than sufficient.
Thank you, sir. Ms. Sitze-Bison, I just remind colleagues that this meeting will end at 5:20. This panel will end at 5:20. Ms. Sitze-Bison.
Thank you, Mr. Chair. Ms. DeRosier, as you know, in 2007, Supreme Court ruled Tchaikovsky versus Canada, that detention without review for 120 days breaches Section 9, which is arbitrary detention, and Section 10C, legal rights upon arrest or detention of the Charter. Do you not think that this new regime, which imposes a delay more than 3 times as long as the one struck down in 2007, may also be ruled unconstitutional?
I think that was my submission, that indeed, on its face, 12 months without judicial review contravenes what the Supreme Court has said in 2007. And there is no reason to justify this change. And in my view, on its face, it's going to be constitutional. And indeed, I think as parliamentarians, it's not a good idea to pass statutes that are on their face unconstitutional, on the theory that maybe nobody will challenge them or the power will not be used, that's not appropriate. We owe it to the rule of law to have statutes that comply with the Charter. We also owe it to other countries around the world that look to us to have statutes that make sense and that are appropriate and do the right balancing between different interests to ensure that indeed they comply with the Charter.
Thank you. I have a question about mandatory detention. So a detention regime, I keep calling it a regime, for designated foreign nationals, as people will be called, provided by Bill C-31, has attracted considerable attention, as we know, because it is a violation of rights that with the violation of rights incompatible with the Canadian Charter, and of course with our international obligations. What is your opinion on this, and what alternative can you suggest that you would recommend for dealing with mass migrant arrivals?
Well, certainly, I think the bill, the current statute, the current way in which we have dealt with group arrivals is not inappropriate. In the statute, it does say, to the extent that there's some difficulty in doing the identity check and so on, people can be detained for short periods of time. But at least there's the guarantee, and there's that indeed a judge is there to make sure that the process works well. We should value this. We should value this profoundly, because that's what constitutional law is all about. That's the protection that we all have, that if indeed we are found to be detained, we're not at the mercy, like this bill, that you're completely at the mercy as the minister deciding that, oh, yeah, exceptional circumstances, I decide you can leave, even if he or she does the right thing. And I think there is a flaw, a symbolic flaw here. There's a symbolic flaw because it does say to people, you're in Canada, you're completely at the mercy as a minister deciding what happens to. That's not what we're all about. We're a society based by the rule of law, not by discretion exercised at the whim of a minister. So I think, to me, I react as looking at this and saying, will I want this to be part of Canadian law books? I say no. See, I think there are some dangers in terms of the way it transforms our constitutional law, let alone all the problems that may have on the individuals that will be affected, which is serious enough, but there certainly are some problems on the way in which our constitutional law will be transformed.
So my understanding is that the current system that we have actually works.
I mean, certainly not in terms of there's some improvement that could be made. More people could be done, and certainly I think you certainly want to ensure that there's some more speed in the system. I have no problem with some of the parts of this, but on this, on the necessity, I think there is absolutely no necessity for this mandatory detention for 12 months of people arriving to Canada. Absolutely not.
And then the power, all of the power being sitting in the one seat of the minister is, once again, in your opinion, is?
I think it is a flaw. I think it is a flaw. I think it's against the nature of what we should expect in a parliamentary democracy.
Thank you. We heard from witnesses earlier, and the minister as well, and the ministry staff earlier today about Australia. So I'll ask you about some of the stuff that's been happening on there. We've seen the statistics from Australia showing that mandatory detention did not discourage asylum seekers from coming to Australia or from going to Australia. Is there any explanation for why mandatory detention did not work there?
Well, in our view, it doesn't matter whether it works or not, because it is inappropriate to do it. It's an insult to all Canadians, because the minute that you start deciding that there could be mandatory detentions on a group, then which will be the next group? And that's the reason why I ask you to think about that seriously. I have absolutely confidence that there would not be a minister of this government that would do it, But some other governments could do it. What's to prevent another government somewhere else to saying, I designate this group and I put them in mandatory detention for 12 months? Canada can do it. Why not us? I think it's dangerous, and I think it's inappropriate. So irrespective of its effectiveness, it is debated. I'm not going to get into that debate. I think it's wrong.
So this bill basically opens a door for a future government to be xenophobic towards any group of people. Okay. Is that what your understanding as well?
Well, I think that's one possibility, and it's the duty of these parliamentarians to prevent this from ever occurring. It has occurred before. It could occur again, and I urge you to protect our reputation for the future.
Thank you. I have more time, Mr. Chair?
You have about 30 seconds, so if you can.
Okay. Did you want to continue saying it at 30 seconds?
30 seconds.
I'll pass it on to Madame Grosguet later on.
I think you have something to say.
I think it's important also to recognize that it's not true that refugees have not been good immigrants in Canada. You know, they have contributed a lot to Canada, and we should be proud to have accepted refugees in Canada. And I think this is important to recognize. This is not about trying to belittle the heritage that they have contributed, and I worry sometimes about the tone.
Thank you. Mr. Lamoureux.
Chairperson, I really do agree with your last comment, and there have been actions taken by this particular minister and this government that I think have raised the concern in regards to that very issue, whether it's standing on the back of a ship that I made reference to earlier in question period, or it's coming up with this whole detention idea. One of the things that we learned today, and I posed the question today in question period, is in fact that the current system of detention is actually working. It has proven itself to have worked. We've now taken, and Mr. Dijkstrik has asked for Liberal Party to come up with some ideas, amendments. We're suggesting that whole section be amended out of the current legislation. And it's safe for me to assume that you would be very supportive of taking that whole section in terms of detention out. You fully believe that the current system is doing what it needs to do?
Well, I think there's certainly some ways in which the system, as it has been applied at times, we would disagree with the way it has been applied. But on the whole, I think at least it does satisfy the interest of the minister. This section that imposes mandatory detention for 12 months without judicial review is wrong. It should be removed from this act. In my view, it is constitutionally wrong. It's wrong at international law. It's wrong even for a constitutional democracy.
Well, we agree on that point. The minister says he's open to ideas, amendments. Let's hope that we'll find out whether or not he's actually open to amendments, because the Canada Border Services is the group that said that it's actually been working. There's the irregular arrivals, and then there's the safe country list. These are two new initiatives in which the minister himself wants to make those determinations. It's outside of the safe country list that we passed just a couple of years ago, where there was a consensus that there be an advisory group, and that advisory group is the one that would recommend which countries would be put onto the safe countries list. I'm wondering if you can provide comment as to why it's important that decision-making be not left with the minister, but be left with some professionals such as an advisory committee.
Yes, in our view, I think we have always taken the position that it's dangerous to politicize too much this safe country list. An impartial advisory group that makes recommendation is a good idea. Why prevent the minister from getting good advice prior to making a decision? It seems to me it's reassuring to Canadians to know that indeed it is not because some country is putting pressure for commercial or other interests that they want to be on the list or off the list. It really is because there's independent advice that says, indeed, this is a safe country or it's not a safe country. I think there is some dangers in having a safe country, so that we do not presume that, indeed, all countries never persecute somebody. We're certainly happy that there could be some distinctions, but we have to remember that indeed, we cannot say for the future that no country will ever persecute its own residents. Indeed, one of the idea at international law is that you are entitled to an individual assessment of whether or not your claim is valid. And I think, it's very compatible with what Canada is all about, which is, individual assessment of someone's claim. So my point, just to clarify, is why not have an independent assessment? Seems to me it would certainly remove at least the likelihood that somebody may worry. And that's enough to worry about the legitimacy of the decision.
Yeah. Another good amendment that could likely come forward. The other issue is the irregular arrival. Is there anything that you would like to recommend to the committee that could put some sort of a check or in place that would deal with the concerns in regards to this whole labeling of irregular arrivals, or is it just a bad idea?
It seems to me the irregular arrivals make no sense in the long run, because if you look at what does the bill say, it says two things about irregular arrivals. Number one is they're going to be detained mandatorily, and I've said several times that I think that's wrong for many reasons. And the second one is that it creates a different category of refugee even after they obtain their refugee status. Once you've obtained your refugee status, I think Canada deserves that you be given the full chance of contributing right away to its economy, and therefore you should be able to apply for permanent residency the same way as any other refugee. So to me, this categorization in itself is not sustainable. So those are our
Thank you,
suggestions.
Madame Rosier. Mr. Menengakis.
Thank you, Mr. Chair, and I'd like to thank our witnesses for appearing before us today. Mrs. Taub, I confess I was deeply touched with the sharing of your personal story. Thank you for sharing that with us. It is, I think, a testament to the great country that we live in, that we have before us the offspring, if you will, of a Holocaust survivor, and the good work that your daughter is doing. It's wonderful that you've dedicated your life to making Canada a better place to live as well. So thank you for being here with us. On Radio Canada International, you said, and I quote, "I'm an immigration and refugee lawyer in Ottawa and a former member of the Immigration and Refugee Board. I can tell you from theory and practice that the current refugee system is very flawed and cumbersome and definitely needs an overhaul. It takes up to 2 years to have a claimant have his hearing. And there are far too many bogus claims that clog up the system and use very expensive resources at a cost to Canadian taxpayers." Now, I have a number of questions for you. And the first one, obviously, as the ministry, the minister, and the government has a different opinion as to the compliance of the bill with the charter. And I'd like to hear your opinion. Do you agree with Madame de Rosier's
That's okay. Rosie is fine.
view that the bill is not charter compliant?
Well, regarding the mandatory detentions and designated groups, I think there was confusion created because designated countries of people coming from designated countries are not the same as people coming from irregular arrivals, that is through smuggling. So I think if someone doesn't know the bill in detail, they'd be confused and think, oh, well, if somebody comes from the United States, they're going to be subject to detention. That is not the case. This mandatory detention has absolutely nothing to do with people coming from the designated countries of origin. The mandatory detention refers to people who have been smuggled in. It's completely different, and I just want to clarify that so there's no confusion. If somebody comes in from Hungary or France or New Zealand or Australia or Norway, that they're going to have mandatory detention because they're from a designated safe country or a designated country of origin. As for mandatory detentions for 1 year, I really don't see how that could even happen because he said he's going to accelerate the cases, and they're supposed to be maximum finished within 216 days, so there won't even be a mandatory detention of 365 days. And I don't believe that what's in the bill, unless I'm completely wrong, means that every single person is going to be stuck in jail for 1 year. I think we'll probably be looking mostly at the smugglers themselves, and if people do not destroy their documents upon arriving, which are en route, it'll be easy for the board to determine who are the smugglers and who are the people genuinely seeking claims. But it doesn't help when everybody destroys their documents, and I think perhaps a detention at that point when you come without documents is necessary, because how else are you going to find out who's arrived at your borders? What is constitutional and what is not constitutional? I'm not a constitutional lawyer. However, I may comment that at some point Canada has to determine who's running the country. Appointed judges who are not elected and not responsible to people, or Parliament. And I'm afraid we have shifted away from a true democracy where our laws are created by Parliament but determined by a Supreme Court or other federal court whether it should work or not. And they are not elected, and they can stay in power till the age of they are appointed and can remain in their judiciary capacity till the age of 75, and are answerable and responsible to no one. Sorry, but did you ask me another question? Did I miss the point?
I have more questions, so I'll just go on if I may. With the new measures in this bill, in C-31, the time to finalize a refugee claim would drop from the current 1,038 days to 45 days for claimants from designated countries of origin, or 216 days of all other claimants. Surely that is a big advantage for the folks that actually need that assistance and need that help from us. Can you give us some theoretical and practical examples of how and why the current system is flawed?
Well, I've had this woman whose claim from Djibouti was on since, I think, the fall of 2009, and she was constantly calling me. We had her claim heard in February, and she was accepted. But she was calling me regularly, and I kept sending in requests down to Montreal to find out, giving them a list. Look, it's 2009, early 2010. Please schedule these claims. And I kept assuring her, no one's going to deport you. You're not going to be kicked out of the country. You're a refugee claimant. You are safe. Your children are safe. But she was literally on the verge of a nervous breakdown until we had her hearing and she was accepted. It shouldn't be like that. There are clearly refugee-producing countries that everybody can agree with are refugee-producing countries. And they shouldn't have to wait 2-3 years to have their claims heard. So I'm very happy that they're going to accelerate the processing, but I'm not happy that they're cutting back CBSA positions, because these are the people that help get the paperwork, do the research, do the background checks on the claimants. So it doesn't make sense to me.
You made a valid point any time, sir?
Quickie.
Yeah. You made a valid point when you used the European Union example of 27 countries that people can go to. Why do you think they seek Canada for asylum rather than going to a country that is closer to them?
Well, I don't know. I know that if they want to go and live and work in another EU country, that's exactly what they have to do, live and work. They are not entitled to welfare when they arrive in one of the 26 other countries. Whereas when they arrive in Canada, they are not obliged to live and work. They can work. They can get a work permit within 2 months. And I'd say 95% of my clients have always gotten their work permits and have been working until the time of their hearing and are, fully adjusted to Canadian life. And I suspect that might be one of the reasons, because they can come here and live and not work.
Thank you.
And get subsidized housing and social assistance.
Thank you, Ms. Taub. Madame Derosier, Ms. Mendelson-Aviv, thank you for the three of you for coming and making your presentation to us today. It's been helpful to the committee. We will suspend for a few moments. Thank you. I know. All right, we'll call the meeting to order, and this meeting will conclude at 6:15 when it's expected bells will ring to summon us to the House of Commons to vote. We have with us two witnesses, the Ontario Council of Agencies Serving Immigrants, and there are two representatives, Debbie Douglas, the Executive Director, and Francisco Rico Martinez, the Regional Director of Toronto. Yes. Good afternoon to you. You will have, one of you will have up to 10 minutes, or however you want to split that. We have from the Ministry of the Attorney General of Ontario, Tony Scarica, who, Crown Attorney, used to be from Hamilton. He's still from Hamilton.
Still am.
Mr. Scarica, I might as well tell my colleagues we have something in common. We used to be members of provincial parliament in Toronto when we were much younger. Welcome to the committee,
Nice
Tony.
to see you again, David.
Yes. So, who wants to go first?
I'll begin for
Okay.
Cassie. Thank you for having us. The Ontario Council of Agencies Serving Immigrants, better known as OCASI, we're the provincial umbrella for agencies that work with immigrant and refugees communities here in Ontario. OCASI is, and our member agencies, we are very concerned about Bill C-31. And we were actually asking, and let me start off by saying this, that this committee recommend that the bill be withdrawn and that we move forward with Bill C-11, which is scheduled for implementation at the end of June of this year. Just very quickly, we are concerned that the bill would create a multiple-tier system of refugee protection in Canada, which we believe could result in some claimants being denied the right to appeal. It makes refugee protection in Canada dangerously vulnerable to political whims rather than ensuring a fair and independent decision about who is a refugee, and it subjects some refugees to different and harsh treatment based on country of origin or mode of arrival, and whether or not the person has citizenship in Canada, as it has to do with revocation of permanent residency. Although I just wanted to set the stage a bit in terms of how it is that we have been addressing issues of refugee asylum seekers before I pass it on to Francisco. In 2010, Canada accepted about 24,000 refugees in all classes. This was about 11,000 fewer than the 35,000 that were accepted in 2005. In 2005, refugees in all classes accepted in Canada were about 13%. In 2010, they were down to 8% of all permanent resident arrivals, which was a drop of almost 5%. In 2005, the number of refugee claimants present in the country constituted 0.3% of the Canadian population. 5 years later, in 2010, the percentage of refugees compared was slightly lower at 0.28. In 2010, we accepted 3,400 fewer claimants than 5 years earlier in 2005. At the same time, the number of people forcibly displaced in countries around the world was growing. We believe and we are concerned that Bill C-31 will reduce even further the number of individuals who seek to enter Canada in search of asylum. The Minister has said that Canada welcomes more resettled refugees per capita than any country. Meanwhile, according to the UNHCR Global Trends Report of 2010 that was released last year, 80% of the world's refugees are in the global south, in the world's poorest countries such as Pakistan and the Congo. The report found that roughly 43.7 million people are displaced worldwide. Of that number, 27.5 million people are displaced within their own country due to conflict.
In this global context, Canada's involvement in resettling refugees, while admirable, I don't think any of us around this table is arguing that, doesn't quite measure up, though, to the commitment of other countries in the world. According to the same UNHCR report, in 2010, Canada had 4.2 refugees to GDP per capita, compared to Pakistan at 709 and Congo at 475, Kenya at 247, and Chad at 224. The comparison becomes more stark when one considers the fact that Canada's GDP per capita is considerably higher than that in the countries named. We are also deeply concerned about the growing anti-refugee sentiment in Canada and the extent to which this could be exacerbated by the government messaging about the bill. And I heard some of the language used earlier today while I was listening to some of the other witnesses present and to the question and answer period. Messages that characterize asylum seekers in stereotypically hurtful ways, suggesting that they are bogus and are a drain on Canadian society, can have a harmful effect. We are also deeply troubled by the misperception that these measures are necessary because Canada is facing supposed floods of refugees. This messaging contributes to increasing tolerance towards refugees and has a harmful impact on the resettlement opportunities in Canada. While we believe that most of the measures are quite problematic, let me just concentrate on two pieces, and then I promise I'll shut up. It's shorter time limits, and I know that the previous witnesses spent some time about this, but we are particularly concerned that the shorter time limits will pose additional difficulties for particular claimants. We are particularly concerned as a council with lesbians and gays and trans folk, as well as women fleeing domestic violence, who often need to develop some sort of trust before they will disclose or come out, as we say here in North America, about their sexual orientation or about their search around gender identity issues. We believe that this will present increasing difficulties in terms of them having their claim together in the 15 days to submit claims that's been proposed in this amendment. And for me, this is also tied to the safe countries list. And I won't go on and on about the safe countries list. I think you've heard many arguments about ongoing concern, but we absolutely know that in countries that Canada deemed to be democratic, in countries that we may have trade agreements with, in countries that we work closely with outside of the EU, because I think you've all heard how safe the EU is, I guess for particular groups of people. But we are certainly concerned that there are democratic countries where particular groups still face severe discrimination, and discrimination that often and at times leads to severe physical abuse, but also at times to death. And I think that we have, even here, in the Americas, we have example of this. I think one of the stories that I wanted to share just briefly, which is about 4 years old, was about a young Mexican woman who was sent back, whose claim was refused, and was sent back and was killed. But unfortunately, there was actually a more recent case that come up, and which is the case of Veronica Castro, who once again comes to Mexico. Her claim was denied. A year before she was deported, she was saying to friends, "This decision is a life and death decision for me. I will be sent back, and I am hoping for your prayers." She wrote to one of her friends that her deportation was a matter of life and death, and said that, and I quote, "I'm shaking and terrified every time I think about my deportation. I am really scared." 33 days later, after being deported back to Mexico on January 12, 2012, she was murdered. So those are the kinds of stories that we know, and those are the kinds of stories that we are concerned about if we were to move forward as a country in adopting this bill.
Briefly, bon appetit. to all of you.
Continuing on, I was dying here. Thank you.
No problem. We have more than 200 agency members of the OCASI, and they are across the Ontario, and they work with refugees and immigrants. And we are the people that deal with these refugees and immigrants that stay here for more than 1,000 days, and they go to different refugee hearings and finding a lawyer and whatever. And we are very concerned about the people that are already in the system. If we, the CIC, basically Immigration Canada, said that it's around 40,000 applications for humanitarian and compassionate grounds that are still in the system without any decisions. The IRB accepts that the backlog of cases that haven't been decided is 40,000 cases as well. And in this case, we have many applications for PRA that haven't been decided. We believe that it's around 100,000 people that are affected in this particular backlog situation that they are. And we are here to ask you if you can consider a Jubilee program for the people that are in the backlog situation, because they have been waiting and waiting for this change. We advise them that the law is going to be changed in December 11. Doesn't happen. We advise them that the law is going to change in June 2009. Doesn't happen. Why? Because now we have a new bill, and it's going to move the implementation date on many reasons, on many situations, to maybe December or more. So in that case, we want to ask for a program to help the people that is already here working, using the criteria of economic integration, social ties to Canada, etc. So that's one of the things that we want that you consider.
Thank you very much. Then we have Mr. Skarica, who we have two documents. One has been translated. It's called Crown's Provable Statement of Facts Experts, and that's, you all should have that. There's another document which is just... What? You've been busy, Tony. You've been very busy. Well, the problem is they're all in English, and so do I have unanimous consent that these can be distributed? Agreed? Agreed. Okay, Madam Clerk, and maybe while they're distributing it to you, you could speak, sir.
All right.
10 minutes.
All right. I'm the lead prosecutor in the largest human trafficking prosecution in the history of this country. We've convicted 8 people so far of human trafficking and participating in a criminal organization. We've convicted 7 other members of other various offenses. Another person is going to plead guilty to human trafficking and participating in criminal work tomorrow. That doubles all the convictions since the implementation of the human trafficking legislation in 2005. I've called it the invasion of evil. And the reason I've done that, and I've done it publicly many times, and I know maybe some people think it's politically incorrect, the reason I call that is the brutal truth is that an entire criminal organization that was active in Hungary came over to Canada unmolested and then set up shop here, and they've been working with their people in Hungary, and they've been doing this now since at least 2008. So the first thing I'd like you to see here is the invasion of evil came in 2 waves. The first, you have a chart that you could look at. I put a yellow on the first wave. Do you have the chart there? Where's the chart? You need the chart.
They're just in the process of distributing it, so I don't know where it is. I don't know how to stop the clock.
Okay, well, I'm just going to keep going because I only have 10 minutes.
Keep going.
Okay, so the chart shows you there's 5 people that are yellowed in. That's the first wave. Back in 2000, back when they came in 1998, there was no visa required for Hungarian refugees. These people claimed refugee status. They were indicted 9 months before they came for extortion and fraud. And if you want to talk human trafficking, what is it? It's extortion and fraud. So they came over here 9 months later. Warrants for their arrest were issued. They made refugee claims. And in a refugee claim, you have to say, I have no outstanding charges. Well, for some reason, nobody ever found out about that. They made their refugee claims. CBSA is supposed to check for outstanding charges. Or you click on their outstanding charges, criminal records. None of that ever came up. They became convention refugees. They became landed immigrants. One of them became a Canadian citizen. And in fact, in this other document that you have, tab 10, 2005, I don't have time to go into it, but if you look at it later, you'll see that the Canadian authorities and the Hungarian authorities knew that the Frank Domator, who's the ringleader, had those outstanding charges. Nothing was done about it. A year later, those charges were dropped in Hungary because of limitation problems. So now we have two serious criminals in our country who are landed immigrants. One's a Canadian citizen. Throughout this entire process, they're hiding in the open. Nobody ever seemed to find out that they were, in fact, wanted criminals from Hungary. So after they got their status, the next wave came over, and that's everybody else at the top part of this chart. And everybody else in this top part of this chart, there are their relatives, and every one of them except one, when they came in the country, or very shortly afterward, had outstanding charges. Some of them had criminal records, some of them had outstanding charges at the time, some of them had outstanding charges shortly thereafter. They click on the little form, we have no charges. All of them came here. Nobody ever seemed to find out that they had these outstanding charges. And so once they were all here, they rented homes, and then they started recruiting victims from Hungary. And they are all here, 19, and there's lots more. We are 19 for sure. And they started making a lot of money. If you look at those photographs, about 2009, $600,000 homes in Ancaster. There's the ringleader, and they lived in the most lavish lifestyle. Meanwhile, their slaves were living downstairs in these beds. This is the number 2 guy. This is a $600,000 house. Those are the 2 people that came originally. Okay, so how could all this happen? The lieutenant, a guy, I'll give you an example, Frank Karate, he pleaded guilty for 6 years minus credits. How much have I got left? 5 minutes?
Oh, you got over 5.5 minutes.
Okay. Frank Karate pleaded guilty for 6 years minus credits. He came over just like those other 2. Came here, said he wasn't charged with anything, came into the country, CBSA did a check on him, and he came across as no record. In the court documents, after he was charged, I wanted to know, well, what's their background in Hungary? And if you go to this white document, Affidavit Lepa Yankovic, Exhibit 37, there was an international arrest warrant for him and his wife as well. But when we checked for his criminal record, and there's no time to go into it now, but just trust me on this, Exhibit 38 said Frank Karate had no criminal record. A month later, the Hamilton Spectator went to Hungary and said, what do you mean this guy's got no criminal record? Not only has he been charged, he's been convicted, he's supposed to serve 5 years. Hungary has this neat little procedure where they don't put you in the jail right away. They say, hey, come a month later, go to jail. And guess what? They're coming here. And then when they come here, they say they have no criminal record, and they check it off. And somehow when we check, there's no criminal record. So 3.5 years later, when he pleaded guilty, 3.5 years, I still didn't know what his criminal status was. So finally, tab G on this document here, guilty plea synopsis, tab G outlines his history. He, in November 6, 2008, he came to Pearson, non-genuine visitor, go away. Came back 2 weeks later, Trudeau. Got in the country. Then he said he was a refugee. Frank Domator, the leader, said he would be responsible. Criminal history check, March 18, 2009. No foreign criminal record. But September 10, 2009, CBSA says, he is wanted in Hungary. What for? Well, we don't know. September 24, 2009, he's wanted on a European arrest warrant. And then 2 years later, I'm told he's got no criminal record. Well, what is his criminal record? His criminal record is there at tab G. 1996, receiving stolen goods, sentenced to 1 year imprisonment. 2003, bodily injury, 9 months imprisonment. Fraud, fine. 2009, blackmail and fraud. That's what human trafficking is. What did he get? Almost 5 years. But he came here. And he was getting paid welfare. His wife's in the same boat. How much time have I got?
3 minutes.
Okay. Tabby, his wife, she's wanted too. She did the same thing as him. She took off. And when she got here, there was international arrest warrants, so on and so forth. If you go through the documents, the Canadian authorities finally were told by Hungary in May 2010 and August 2010 and October 2010, hey, there's international arrest warrants for her. What was done? Nothing. So finally, in 2011, we're doing a bail review on her husband. I see her walking around in court as a spectator, and I go to the officer, what is that? I thought there was an international arrest warrant for that person. Well, there is. Well, why don't we arrest her? We can't. We need an extradition request from Hungary. We've never had one for any of these people. So, what we do, I go to Deb Kerr, who's from CBSA. How can she be walking around our country with international arrest warrants? She's been convicted. She's been convicted of crimes, we think, but we don't know. So she did the check in tab E. If you go to tab E of that same document, there it is. Yes, she has been convicted. She's supposed to serve 2.5 years. Same procedure. Come back in a month. Go to jail. Well, she comes here. And what's the date of this document? November 21st, 2011. 3 years she was in our country, and we didn't know what her criminal record was. And this is not cheap. If you go to the Karates, tab 1 of this, they were also, we charged them with welfare fraud. By the way, she was arrested shortly after it, because Deb Kerr, I said, well, we got to do something. She finally found out, well, she is in fact been convicted, and she did the little tick that she wasn't guilty of, she'd never been convicted of anything, and that she got arrested on an immigration warrant. But in addition, she and her and him were convicted of welfare fraud. He had to pay back $12,000. We'll never see that again. She has to pay back $36,000. We'll never see that again. That's in fact cheap, because more recently we convicted these two people. 1 minute. And we convicted these two people, and they've been on welfare since, these are criminals, and they've been on welfare since they've got here, and they have been paid $100,000. And like I heard all these anecdotal evidences, you know, these people, they have all kinds of money, and they got cash, and so on and so forth. So when this guy was fleeing the country the other way, if you go to Exhibit 10 here, and I don't know how they do it, but these people get really genuine Hungarian passports. I don't know how they do it. They're in Canada, and they get them. And anyway, in his suitcase, a guy that we paid, and his mom, $100,000 in welfare payments, all these designer clothes, with the label still on, $100 here and $100 there. That cost us, they cost us $100,000. So we called evidence. Basically, these Hungarian refugees, 98% failure rate. When it's all said and done, if at that same rate, $500 million, just them. $500 million at a time when there's no money for doctors and hospitals and nurses and what have you.
You're even more passionate now than you were years ago.
I can't believe this is happening to our country.
Well, your time's up, I'm afraid. Ms. James.
Up in the 6th hour of debate on this bill, so I thank you for that. I'm listening to you, and I'm not shocked, because I sit on this immigration committee, so I've heard the stories. But I have to tell you, the constituents in my riding of Scarborough Centre are shocked. They are shocked at the illegal fraud that goes on with our immigration and refugee system. And you actually mentioned it very briefly with the welfare fraud. I think you even said $100,000, if I heard you correctly.
$50,000 for them, but we've had over $200,000 now just for these people.
It's a huge problem provincially in Ontario, because bogus refugee claimants, or people who come here by fraudulent means, are here long enough to make their applications to start receiving our lucrative benefits, but then they don't necessarily show up for the first hearing, and then, of course, it's hard to track these people down. So I'm listening to your story, and I'm shaking my head, not in shock, in agreement. It's very upsetting, especially to the cost of Canadian taxpayers. And I'm just wondering, the provisions in this bill in BC 31, if you could tell this committee why generally you accept these provisions and why you think they will make a huge improvement.
Well, they'll make a huge difference, because the evidence I called at the Stoikas was that it costs us an average of $50,000 for failed refugee claimants. So for the Hungarians alone, that's $500 million. So that's the road to bankruptcy, in my opinion. So my druthers, I think it should be even stricter than it is. I think you're being very generous. One thing that the legislation doesn't address is What's happening to Hungary? They haven't done any arrests over there. They're lying to us about what's going about their criminals. I've said it in court. They're trying to dump their criminals on us. Well, why is not something that's being done with Hungary? Why are there no extradition requests? There's all these recruiters out there. How come not one person has been arrested over there? We had people threatened that we had to get out of Hungary to preserve our prosecution, and they haven't done anything. How can that be a friendly nation?
Thank you. We're talking about countries from the European Union as being designated as safe countries. It's hard to believe, and again, it's not hard to believe from my viewpoint because I'm on this committee. I know the statistics. 25%, almost 25% of all refugee claimants are coming from the European Union. This is a democratic number of countries where you would not expect refugee claimants to be coming from. And our last witness was quite passionate about legitimate refugees versus those that are shopping around for the best benefit package they can find. So having said that, when we talk about the European Union, it's actually costing Canadian taxpayers $170 million per year. And I think that's a number that we need to say more and more because people cannot believe the cost to Canadian taxpayers. What is your idea? What is your comment specifically with designating safe countries where, you know what, you really shouldn't be getting refugee claimants? And in fact, the statistics on those that actually withdraw their applications or abandon it altogether, 95% from the European Union actually abandon those claims, but they're, again, long enough to start collecting the benefits.
Hungary's even higher. It's 97, 98%. I think there should be mechanisms to get them to leave quicker, because with that kind of failure rate, 98%, it's pretty well everybody's coming in. And what I've heard, when the police investigated the people, the Hungarians coming over, why are you coming here? Why don't you go somewhere else? Well, Australia, etc. They're coming here because in Hungary they're told, and I don't know if it's true or not, but it's probably true, we have the most generous welfare package for refugees in the world. That's why they're coming here, because they get the best deal here.
And this bill isn't just to, crack down on bogus refugee claimants. And I know the other witness actually had made a comment about asylum seekers when it's a harmful effect on them if they think that we think all asylum seekers are bogus refugee claimants. But that's not the case. And we all know that's not the case. This bill is aimed to crack down on those that are abusing our generosity, but at the same time it's also allowing Canada to accept legitimate, bona fide refugees into Canada, way quicker than it has been in the past. Some of these people need our assistance, and this bill aims to allow them to get that assistance and support much quicker. What are your comments on that?
My own parents are refugees from World War II, so obviously I'm here because ultimately Canada's a generous place. But there's a difference between generosity and being fools. And when the world knows that you can come here and lie on a form and nothing's going to be done about it and you can get welfare for 4 or 5 years, that's not generosity, that's stupidity and road to bankruptcy. So I welcome this bill. In fact, I think it's not even strong enough in dealing with the bogus refugees.
And we actually had another person here on February the 6th. Actually, it was, not in this committee. Richard Curlin, an immigration lawyer, who was quoted as, and he was referring to the minister, finally someone has recognized that the open wallet approach of the past, offering free education, free Medicare, and a welfare check to anyone who touches Canadian soil, finally we have someone that will take a look at that particular aspect.
They know the system. Virtually every one of those people you see at the top of this list, they know that when you come to Canada and you go on welfare, in fact, the Karatis, for example, they go to some doctor that they have in Toronto, Dr. Sajo, who says, yeah, you got a problem with diet, and they get an extra diet allowance. So they know right away how our system works and how you can maximize benefits.
Can I just ask how much time I have left? Okay, I'm just going to keep talking. When I think of this bill, BC 31, I think of it being in the best interests of Canada as a nation. I think it's in the best interests of the safety and security of the Canadian citizens and the people that are here in Canada. I also think it's in the best interest of Canadian taxpayers, and let's face it, they're the ones that are footing the bill for fraudulent claims. And I also believe that this bill is in the best interest of legitimate refugees, bona fide refugees who need Canada's help. Would you agree with all those statements?
I would agree. And
can I ask you a question?
Yeah, go ahead.
Who is not going to like this bill?
Well, these people, the people at the top of this list.
So it's in the best interest of everybody else except for the people that are seeking to abuse our generosity.
Yeah.
Thank you very much.
Thank you, Madame Grugouet. Excuse me, for those of you who don't speak French, there are earphones, and you can hear, and when you want to speak, there's a red light. Now you can start the clock. Thank you.
Okay, thank you. Merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you to our witnesses for being here this afternoon. In these debates on C-31, on a number of occasions, we've heard the statement that asylum claimants are abusing of Canada's generosity. What would you say to that? Ms. Douglas, please.
I think that we generalize to the detriment of those bona fide refugees that we keep hearing about while we continue to talk about refugees as a group who are taking advantage of our system. But I think Francisco wanted to comment on this specifically.
You have to check the percentage of refugee claimants that end up in our criminal system, and it's very, very low. And the bill is not going to catch these people. Then Mr. Carica is very passionate about it. Why? Because the refugee hearing will be in 30 days. And there won't be enough time to do a criminal check of anything. This person could be accepted as a convention refugee. Very easy. Because one of the problems that he detected was that the RCMP, CBSA, and whatever doesn't do the checks that are need to be done. You know what I mean? Other countries lie. What he is very clear about it is that Hungary is a safe haven for criminals in that particular sense. How we are going to deal with that situation here in 30 days? Maybe the person will be accepted, and we are going to have an issue if that person is accepted. So I think the double checks are important, and that's why the shorter of terms, when we have a system that is proved and doesn't work in many circumstances, is a problem.
I should say that the latest statistics from the Ministry of Community and Social Services in Ontario does not bear out the fact that refugees and immigrants are overrepresented in our social assistance system, and we can certainly take a look at those stats.
Okay. Nous avons fait en tant que pays
As a democratic country, we've made great progress with respect to fundamental rights of individuals. One of our witnesses earlier on mentioned the importance of a society based on the rule of law and not on the discretionary power of one individual, i.e. the minister. To you, when it comes to democratic countries, do you think Minister Kenny said that that democratic countries are safe countries. He said that they cannot produce refugees. Do you share that view? And do you have any examples to prove the opposite?
I think that one of the arguments we have been making is that there are people who belong to particular social groups, even within democratic countries, who are discriminated against and at times are even killed. In particular, we're looking at lesbians and gays. For example, I come from the Caribbean, and this is not to stereotype or generalize about Caribbean culture or practices, but we do know that there are a number of gays and lesbians from some Caribbean countries who have had to flee and who have had to flee to Canada for protection because of their sexual orientation. Will our minister deem them to be a democratic country? Absolutely. They sit together. They're part of the Organization of American States. We have very good trade relations with the Caribbean, as we should, but at the same time we have to recognize that there are particular groups of people who need Canada's protection even when they are born and live in countries we deem to be democratic.
And in the other hand, one of the main problems that we have with the modification of the designated country of origin is the process with that countries will be determined. In the original Bill C-11, when it was passed, they were talking about refugee rights, the standards of rights or standards of violations in that particular country. And this specialized team is going to analyze that particular concept of the evolution of the human rights issues in that particular country. Now, that situation is gone. And we are going to use only statistics prepared in Canada, rate of acceptance, rate, withdrawal, and, and 30 cases in particular time. That's statistics in Canada. Why we don't go back to the idea of the specialized team that is going to take a look at the human rights levels or issues that are doing in that country and give a report to that? And this is going to work better. 2 minutes.
Okay. J'aurais une dernière question.
I have a final question regarding detention, specifically that of children. We know how important it is to uphold the rights of children. How do you feel the provisions under C-31 how do you think that they will preserve these rights in a tangible sense when it comes to enforcement of this bill?
But it won't. Bill C-31 gives parents the option of no choice. One can have their children detained with them, or one can give up their children to the state. And as someone who is seeking asylum, being faced with Sophie's choice not to at all to belittle the Holocaust, but it is a position of no choice, basically, in terms of children being detained. One of the things that we have been taking a look at is what past practices have shown us in terms of the mental health of young people who have been detained and or removed from their parents. And so those are some of the concerns that I think that this committee needs to take into account when we look at mandatory detention, and particularly when we look at detention of children under 16. Often in Canada we think of the age of adulthood as 18. Bill C-31 talks about children as 16 and under. That in itself is a problem.
Thank you. Mr. Lamoureux.
Thank you, Mr. Chair. I did have a couple of questions that I'd like to ask for Mr. Pronunciation Scarsa? Tony.
Tony's fine.
The Canada Border Services Agency makes a presentation here earlier today, and in essence, they gave very clear indication that the current system in terms of detention seems to be able to meet the needs. Like there's not a problem in terms of extending, keeping people that need to be kept into detention, that they can be kept into detention. There's a certain protocol that has to be followed. But they definitely weren't complaining about it, saying that it needed to change. I raise that issue because I'm wondering, in your presentation, you give the impression that this is a good bill. I would recognize this bill as a bill that affects many different policy aspects of refugees. Would you agree that if in fact the system isn't broken in regards to that detention component, that we should be leaving that? It appears the current system appears to be working with regards to that, and given the concerns in regards to the whole charter, constitution, like is it constitutional to be making this change? In other words, are you open to, or would you believe that there is a need for some amendments possibly to make the bill better?
I think our system is totally broken. If you can have an entire, this is organized crime, and they were active over there, and they came over here and they had records and outstanding charges, and they became landed immigrants and so on and so forth, and continued on crime. To me, that's a system that's broken. And I would think and I don't know all the mechanics of the bill, but it seems to me when these people like Karate, who's a vicious criminal, you have the Hamilton Spectator report there. He's very feared and hungry, and he came here. Well, why shouldn't he be going right away into custody? And why shouldn't we know that he's, in fact, about to serve a 5-year sentence, and he's coming here, and then we're paying him welfare? So my impression from doing this prosecution, our system is broken.
Yeah, but I guess part of the issue of going through the committee process is to try to look at ways in which we can improve upon the bill. And the minister himself is saying that, look, we're open to amendments on this bill. If the current system, and I'm just talking strictly on the detention component, seems to be working, why would you be in favor? Like, are you in favor in just that specific component in changing that?
I don't think it is working. Like people like Karate, who are fugitives from justice, he was in our country for 4 years and we're paying him.
Yeah,
so why shouldn't he go into detention?
Right.
I don't know all the mechanics of how it's going to work, but there's a prime candidate.
You provided the committee this list here. Can you just expand in terms of exactly what Cole's Notes version of what is this list?
Okay, we had in our prosecution, how many people we got charged? We have 15 now convicted. We got 2 more charged, and we're looking for 2. So the people at the top are all the people who are the accused persons.
Currently living in Canada?
Yes, they're all living in Canada. Well, not anymore because we deported some of them. But at the time we laid these charges, the bulk of these people were living in Canada. In fact, they were all living except for the one at the very top, Frank Domatora. He is in Hungary. But the rest of them are in Canada, and 15 of them now have been convicted, and we've deported some of them. But even that doesn't work. Victoria Nemes, see that name there, Victoria Nemes? She's for Karate's wife. She was convicted of welfare fraud. We gave her a deal. Basically, she'd done 2 months in custody. I said, okay, let's give you a suspended sentence because you go to Hungary and you serve your sentence. Well, you know what? Is she in Hungary right now? No. She got her suspended sentence. CBSA paid for a ticket to Hungary, but it wasn't direct to Hungary. They sent her to Poland first without an escort. So guess what happened when she got to Poland? She looked around. There was nobody there. She walked off the plane. She's not in Hungary. She's not serving her sentence.
And where are the victims? You have a lot of
victims. They're all. Some of them are in Hungary. Most of them are in Canada. They're too afraid to go back.
Ms. Douglas, I'm wondering if you could maybe provide some comment in regards to the detention component. Do you have any thoughts in terms of it being mandatory?
Well, as you heard from one of our earlier witnesses, current law allows for detention for us to determine folks' identity. Mandatory detention of up to 12 months we believe to be excessive, given that it's to particular groups of folk who are deemed to be irregular arrivals. The fact that the timing period has been lessened, I don't think minimizes the fact that we have introduced something called mandatory detention without judicial review into our system, when in fact existing policy allows us to detain folks whose identity we can't prove and who we have concerns about.
Thank you. Mr. Dijkstra.
Thank you. Most of my questions are for Mr. Skirika, but I do have a question for Mr. Rico Martinez. He indicated that he agreed with Mr. Skirika that our laws weren't tough enough and that the issue of going after the folks that he's gone after and sought out and achieved 15 convictions on, and that this bill doesn't go far enough. I find it interesting when, Ms. Douglas, you said at your outset, you said just withdraw the bill because you don't, I'm assuming you just don't like the bill. I mean, to go through this bill and listen to the person sitting beside you, and when you talk about the very issue that we need to identify these people when they come into the country, and biometrics is the one method upon which we can do that, almost foolproof. And you've both said you don't agree with the bill, but biometrics is right in here, like as a way to get at the issues that Mr. Skirika is speaking about. We're talking about tougher penalties on ship owners. We're talking about deterring the abuse of the refugee system, the whole aspect of cracking down on human smugglers. Better tools to successfully prosecute and impose mandatory prison sentences on human smugglers. You're saying, Mr. Martinez, that everything in this bill is not worth looking at?
What I am saying is that we have Bill C-11 that address very similar issues and address it in a more holistic way, and was approved by Parliament. And we don't understand why we have to review this issue when was an agreement among political parties and was approved and was a decent
Let me answer
agreement.
that question for you, because the man sitting next to you is the exact reason, and the purpose of which he's brought forward are the exact reasons we had to bring this issue forward. I was at C-11. I was parliamentary secretary there. I sat in every single one of those meetings, went through the whole process, went through the negotiations. I was proud of what happened with respect to C-11. And a lot of the aspects of C-11 are going to move forward because of C-31. So you don't like C-31, you like C-11, but a lot of what's in C-31 is Bill C-11. So there has to be things in there that you actually appreciate. My point is that you listen to what Mr. Skarikas had to say. You listen to the 15 convictions he's achieved. You've heard from him. That's what he does for a living, that we have not been successful, that our system is broken. Like, we will not solve the problem of what we have in front of us, this problem right here, with C11. C11 will not solve this problem. You know what we'll end up doing if we only do C11? We'll just simply slap down visas on Hungary and hope that that gets us around the issue, as we've had to do with Mexico and as we've had to do with the Czech Republic. That's not the process we want to use. If we're going to enter into agreements with the EU, if we're going to make sure and ensure that our economies are going to be like-minded and we're going to become free trading partners, we have to have a system that the rest of the world believes is at least on its effort foolproof. And the system we have now in this country, as Mr. Skarikas has said, is broken. And simply disregarding C31 and accepting the fact that a majority of what's in C11 is good but doesn't go all the way to solving our issue, I just have to state for the record that I obviously disagree with your position. I respect that you were here. I just wish you wouldn't have stated at the very outset that all of C31 isn't good and it should be removed. And second, that we need to get tougher to be able to identify the people Mr. Skarikas is referring to. And biometrics is in this bill, and you've indicated that it's not worth pursuing.
With all due respect, I think what we said was that we have C11. C11 was a negotiated bill. That C11 addresses many of the concerns that you've raised. To what Mr. Skarikas was speaking.
Point of order. Stop the clock, please.
It would be nice to hear the answer and not have the member interrupt the answer at all points. It would be nice to have some order when a question is asked. Instead of debating the question, allow the witness an opportunity to answer.
It's a valid point, although I don't think there was a question. But Mr. Dijkstra has the floor.
I want to have a couple questions for Mr. Skarikas. If we can get those done, Ms. Douglas, I'll give you at least the rest of that time to be able to respond. Skarikas, you haven't referred directly to C31, and I wonder if you could in terms of what steps it takes to get at the issues that you've brought forward here today.
Well, as I indicated, the major problem for the Canadian taxpayer is that $50,000 for every bogus refugee, and of which from the European Union virtually everybody is. So the traction of the bill, from what I can see, is that instead of taking 3 years or 4 years, and it's been longer for some of these people, you have a process where people are dealt with right away and leave. They won't come then, because right now they're coming because they know they can come here, say 4 words, I am a refugee, and all of a sudden they got $50,000 that they're going to get. And so that hopefully will, they won't even be here, because for 1 or 2 months it's not worth it.
What sort of support do you get from the provincial government on these issues?
What I find astonishing, not a single MPP of any party has said anything about this. In fact, not a single councillor in Hamilton has said anything about this, and they're paying the freight. So I find that amazing, and I think part of it is political correctness, frankly, because they don't want to say, oh, well, we have, they don't want to come out and criticize the Hungarians, or most of these people are Romas. They don't want to use the word Roma because they don't want to be condemned as being politically incorrect, probably the people next to me. So I'm fortunate because I'm from Central Europe. I'm from that area of the world. So the accused called me racist right from the beginning. Using that card, saying, "Oh, you're a racist. That's why you're going after us." No, they're criminals, and they're serious criminals here. And
on a point of order, Chair, I'm finding it very difficult to sit here and listen to some of the verbiage, which is not talking to the point, but is getting to the point where I find, as a parliamentarian, it's very hard for me to sit here and listen to some of that language.
Well, it's a joy of sitting on the committee. I don't think that's a valid point of order. Thank you. Another point of order.
Actually, it was just to provide comment. I can appreciate the emotions and so forth. I just hope that the Ms. Douglas and her companion will be provided an opportunity just to respond because of the arguments being, or the non-question that was put forward and so forth.
Look, this is emotional stuff. I don't, with due respect, I don't think it's. I mean, I've heard it on both sides. I've heard emotional issues on both sides. And Mr. Skirika is not out of order as far as I'm concerned. Start the clock.
I just want to say to the point, I'm happy to provide some time, but I also listened to the presentation and listened to all of the responses from both Francisco and Deb, so I did want to at least give you opportunity to put my perspective out there, but I would like to offer up, and I'll do my best not to respond while you're speaking.
You've only got a minute left.
Well, as I was saying, we believe that C11 as a negotiated compromise is actually a good bill, as it has to do. I think that Mr. Skirika is conflating issues of trafficking with issues of refugee determination. And we absolutely believe that Canada needs to have stronger responses to issues of trafficking, and we congratulate the Ontario Attorney General's Office for moving forward with this case and being as successful as it has been. But let's not set national policy so that we can go after traffickers coming from Hungary. I think that is one of the concerns, that we continue to paint asylum seekers with this very broad brush, and we believe that by demonizing people needing to get protection from Canada, and we couch it in economic terms, and we couch it in language about people abusing our system.
I don't just couch it in economic terms. I also couch it in ways that Canadians deserve fair justice.
We're out of time, and I'm going to have Ms. Sims yelling at me if we don't start her. So you have until the bell rings.
Yeah, I have about 2 minutes. So first of all, I don't see anything in this legislation that is going to fix the problems in Hungary and their penal system. And I think we need to get that very, very clear. The other thing that I want to get out there is this term of bona fide refugees. We have refugees and we have asylum seekers. And when they come to our shore, whether they come with fraudulent documents via a plane or by a ship, we don't actually have that determination until one has been made. So I don't want to use the language that everyone who comes is fraudulent or is a bogus. And, Bill C-11 was praised by the then minister and the current minister of immigration as a work of art, I will say. Those weren't the exact words. And yet, it has not been implemented. So for me to go on to, it's broken, so therefore we have to fix it, when we haven't implemented a solution that went through the legal system, that went through our parliament, it's very hard for me to sit here. And I think some of the rhetoric, and I'm going to use the word rhetoric I have heard today, is fear-mongering, kind of leads people, if they were to listen to certain testimonies, to think that everybody who comes on our shore, including the grandparents of many of us sitting here, or relatives of many of us sitting here, came here because they wanted to fraud the system, and all they come here is to bypass and use and abuse. And I can tell you, I work with refugees over the last number of years who don't like getting money from the state, who get out and work. And they work very, very hard, and they get on, they get their education, and they become contributing members in this society. That's what Canada is. Canada.
You mean like Chung Sing Long?
Canada is a nation that is
exactly
filled.
Mr. Dijkstra, this is not debate. She has.
Canada is a nation that is citizenship.
We'll have a debate.
Yeah, that is citizenship from people all over the place. That's what I'm saying. Just like Mr. Lung and just like Radhika's family as well. But what I really want us to focus on here is the human element. I've never lived in a refugee camp. I'm very grateful for that. But I've read enough, and I've seen enough, and I've worked with enough children who've lived in refugee camps to know that we as Canadians cannot forget our humanity on some kind of a bogus quest to think we can fix what's going on in other countries. If there is fraud, let's go after it. And let's do it in a way that targets those who fraud and not the victims. I know I'm getting out of time, so when you come across the people you work with, Francisco and Debbie, Can you give us sort of a brief human landscape of the kind of situations they've left behind when they've come here seeking asylum?
Well, our motto is refugees are a threat, but refugees are not a threat. Refugees are threatened. And that's when we open the door of our office. And we receive families, single people from everywhere. And the people that are more traumatized are sometimes the ones that they don't understand even why they are here in Canada in the first place, and are children. The children are the last people to understand that. And our suggestion to deal with this situation is to create multidisciplinary teams that are going to address the human needs of everybody, including English, housing, many issues that we have.
I'm sorry, sir, we have to call it a day. The bells are ringing, and the boys and girls have to go and vote. I'd like to thank you, sir, Ms. Douglas, Mr. Sturika, for coming and making excellent presentations to us. This meeting is adjourned. We will reconvene tomorrow morning here at 8:45.